If I want to mention a really urgent matter,
Appellate side or original side?
appellate side.
When you take up the appellate side, mention the appellate side.
Any original side mentioning? Listed matter item number 1, new application, Malati Shaha and others versus India.
Item number 1 is my appeal.
Yes.
Well, I appear for the respondent. Well, a copy of the appeal may be served or not.
Appeal was served. It was only filed after service. No kind of appeal was served.
What is the appeal about?
But the appeal, my lord, is the dismissal of the order passed in the writ petition by the learned single judge. I tell your lordship, my lord. But the appellant before lordship is, my lord, the distributor of LPG in the city of Calcutta under the Indian Oil Corporation, the respondent number 1. Now, my lord, on 14th July 2023, an inspection was held at the godown of the petitioner and certain irregularities were found out. A show cause was issued on certain charges. One charge was major charge. They found that certain cylinders were underweight. Then, my lord, after that, we replied to the show cause, hearing was given, and a speaking order was passed. 1,90,000 was imposed upon me. Now, my lord, we had preferred appeal. While preferring the appeal, the 25% of the amount was deposited. Then, my lord, on 2nd April 2024, my lord,
Appeal is under?
that appeal was rejected.
That's a statutory appeal.
Statutory appeal. That was rejected. Challenging that, filed the writ petition. 1st May 2024, my lord, interim order was passed on the first hearing date of the writ petition, and my lord, everything was stayed. Thereafter, my lord, by the order judgment under challenge, my lord, the writ petition was dismissed.
So your challenge is confined to that 19,000.
No. I am challenging the entire thing.
What else has been done against you? What other penal action?
Only that much. 190 was the penalty. 40% I deposited, remaining 140.
So therefore, that is the penalty is the subject matter
Yes,
of the charge.
that is there. I am
the only penalty imposed.
Yes, I am challenging the from the very show cause itself. Now, my lord, after the dismissal of the writ petition, that 1,40,000 which was pending, that they have automatically debited from the account. So, my lord, at this stage, my lord, I have nothing to pay for stay. Only thing, my lord, everything will abide by the result of the appeal, subject to lordship's kind consideration. And my lord will allow me to file the paper books, and the appeal may be heard any day.
Very well. We'll do that.
Well,
We'll
well,
direct
in the
them to.
meantime,
I'll serve the paper.
No application is appearing before.
No, I did not
That's
take up
why you
any
did not
application.
take
That is the reason.
Learned counsel for the appellant submits that the present challenge has been preferred against an order of the learned single judge, whereby the writ petition filed by the appellant challenging the imposition of penalty of rupees 1,40,000 for alleged irregularities in LPG distribution was
1,90,000.
was turned down. 1,90,000 was turned down. Full next para. It is submitted that in the meantime, the entire amount has been deducted from the account of the appellant, and as such, there is no scope for grant of any stay, comma, due to which no stay application has been filed. Full stop. However, comma, it is prayed that the deduction abides by the result of the appeal. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find substance in such contention. Full stop. Since substance in such contention. Full stop. Next para. Since arguable questions are involved in the appeal, the same is required to be heard on merits. Full stop. Accordingly, the appellant shall prepare paper books, informal paper books, by incorporating all relevant documents and serve a copy thereof on the learned advocate for the respondents. Full stop. Next para. The deduction of the amount from the account of the deduction of the awarded amount from the account of the appellant shall abide by the outcome of the appeal.
That would be 1,90,566. That is the penalty.
1,90,566.
190,566.
Right. Next para. Liberty to the parties to mention the appeal as and when the same is ready for hearing.
But one thing, since your lordship is recording that the debiting is being challenged, but I am actually challenging the entire penalty imposed, 1,90,000.
No, we have said the debiting will be subject to outcome of the appeal.
No, because during filing of the appeal, I had deposited that 25%, 40,000. So
whatever you have said.
Yes.
You have challenged that penalty of
1,90,566. Yes.
Specially assigned matter.
Grateful to lordship. Much
gratefully, Lord.
Item number 2, Sombroto Mondal.
Your lordship's praying for a short Passover. This is grateful, your lordship.
Item number 3, Harshvardhan Lodha with item number 4.
Lord, I appear for
Yes,
the
sir.
respondents.
Yes.
Lord, who were the complainants, Lord, before the institute?
Yes.
Lord, I must tell your Lordship, Lord, Mr. Ohin Chaudhary, senior advocate,
Yes, any
who
resolution has
passed
been
away.
taken?
There's a resolution not to pass any adverse order in the absence of both parties being present.
This is a hearing matter, Mr. Kaur. If you
Yes,
want to proceed, you
absolutely. No,
can.
no, I can proceed. There is no difficulty. Lord, I'm ready to
Let us hear the matter. No difficulty. We cannot pass any
No,
adverse
no,
order
naturally,
because
naturally.
unless the hearing is over, we cannot pass any order, in fact.
I thought I'll just inform your Lordship.
Definitely. Yes, yes.
I took it up.
Mr. Anirban Rai had argued for the institute, which is over with
Yes.
hearing. Now
Lord,
you are for the complaint.
Yes, for the appellants, Lord, Mr. Abrojit Mitro and Mr. Abrotosh Mojumdar had argued.
Yes, yes. They had.
Then, Lord, Mr. Roy was defending his order,
Right.
appearing for the institute.
Yes.
Lord, I appear for the 3 complainants who had jointly lodged this complaint.
Absolutely.
Lord, they are chartered accountants and, Lord, a member of the institutes. Now, Lord, the complainant number 1 and 2, they are, Lord, not only just chartered accountant, they are in professional practice. But so far as the complaint number 3 is concerned, he is employed as a chartered accountant by Keshuram Industries Limited. Lord, this is the main plank of argument of Mr. Mitro, that, Lord, this is a Birla generated, Lord, a litigation or a complaint.
Yes.
But, Lord, let me, Lord, make it clear that, Lord, the complaint was in respect of professional misconduct. And this professional misconduct was for violation of certain provisions of the Chartered Accountants Act. The fact that one of the complainant is an employee has no bearing on these complaints, because either, Lord, the misconduct is proved or it is not proved. It's only at the professional level, which has got nothing to do, Lord, with the litigations ongoing between the Lodhas and the Builders. Because here, Lord, the capacity is as a chartered accountant, whether he has maintained the standard of practice which is required to be maintained under.
Irrespective of your complaint, the institute has to come to a conclusion,
Yes.
and therefore,
Absolutely.
Lord,
Lord,
I just a complainant.
yes, I have just put the ball rolling.
And even if supposing, Mr. Kaur, we are thinking aloud, even if it was motivated by some acrimony between the Birlas and the Lodhas, now even then, this is not the end of the matter. You just lodge a complaint.
Absolutely.
So this does not vitiate the proceeding itself.
Correct. And, Lord, I am not disqualified from lodging a complaint
In any event, yes.
because one of the complainant is working with the Builders.
Right.
That has to be, the complaint is based on the professional misconduct.
Alright.
So therefore, Lord, connectivity has no what should I say?
It's just with the
Nexus
with
to with the-
validity of the proceeding.
absolutely. Now, Lord, the allegation is of professional misconduct. Now, Lord, this professional misconduct is, Lord, guided by 2 sections of the Chartered Accountants Act. One is section 21, the other is section 22. May I just request your Lordship to take the Chartered Accountants Act?
Yes. Yes.
Your Lordships first come to section 22. There has been some amendment in 2006, but, Lord, this complaint is before. So, my lord, I read the original act. Section 22, it says professional misconduct defined. For the purposes of this act, the expression professional misconduct shall be deemed to include any act or omission specified in any of the schedules, but nothing in this section shall be construed to limit or abridge in any way the power conferred or duty cast on the council under subsection 1 of section 21 to inquire into the conduct of any member of the institute under any other circumstances. Now, my lord, two things, my lord. First is that the professional misconduct under the Chartered Accountants Act is, my lord, defined under the schedules. But I was just, my lord, looking at, my lord, the Advocates Act. Advocates Act, Lord, in the Advocates Act, here, my lord, it is defined in the schedule. Therefore, my lord, they are more specific. But in the Advocates Act, I find section 35. Your lordships may kindly have a look. There is no schedule, my lord, under the Advocates Act. It merely says a misconduct and it can be looked into. So, my lord, Chartered Accountants Act is more definite in my humble submissions. Ache, Advocates Act.
Probably it's not there, but in any event, section 22
Yes.
Does not restrict it to the schedule also.
No, it goes beyond that to
Beyond.
21. That's the
Any
second.
conduct of the member.
That's the second part. But the first part is not even under the section 22.
Yes.
Your lordship finds that they have tried to define what would be a misconduct.
Yes.
And I'll draw your lordship's attention to the schedule. But my lord, before that, I draw your lordship's attention to section 21. If my lord kindly comes to, it says procedure in inquiries relating to misconduct of members of institute, where on receipt of information by or any or of a complaint made to it, the council is prima facie of opinion that any member of the institute has been guilty of.
Sorry, so this section 21.
21. Section 21. Just Lord, before. Lord, there are 21 Lord ABCD, but kindly Lord come to the original 21.
Yes. 21 2 you are reading.
21 Lord, it says 1, where on receipt of information. So that your lordship is perhaps looking at the amendment.
22 is also there in the footnote.
Yes.
But that here says, but this complaint was after 2006 and
Yes.
before 2022.
It complaint was
After 2006
after 2006.
and before 2022.
Before 2020.
So the
20, therefore, Lord, your lordship's
previous provision in our statute, in our book says disciplinary directorate.
No, the council shall by notification establish a disciplinary directorate. Has your lordship got that?
Yes, yes. We are reading
Led
that.
by
That
an
is one.
officer of the institute designated as director discipline and such other employees for making investigations in respect of any information.
That is 21-1.
That's 21. 2 is on receipt of any information or complaint along with the prescribed fee, the director discipline shall arrive at a prima facie opinion on the occurrence of the alleged misconduct.
Yes.
And then where director discipline is of the opinion that a member is guilty of any professional or other misconduct mentioned in first schedule, he shall place the matter before the board of discipline. And where the director discipline is of the opinion that a member is guilty of any professional or other misconduct mentioned in the second schedule or both the schedules, he shall place the matter before disciplinary committee.
But surprisingly, this restricts it to the first and the second schedule.
Yes.
Although
But-
otherwise section 22 is wider.
22, Lord, I
22
say,
says this, yeah, but 22 empowers you for other things. Duty cast on the director discipline under 22 says, the last limb of that 22, director discipline under subsection 1 of section to inquire into the conduct of any member. But nothing in this section shall be construed to limit or abridge in any way the power conferred or duty cast on the director discipline
under subsection 1 of section 21 to inquire
to
into
inquire in the
the
conduct of any member.
under any other circumstance.
Yes.
So, Lord, apart from professional
So
misconduct,
21 and 22 read together.
it
Other,
is-
other things are also there.
other things are also. In fact, Lord, the complaint was on 30th of June 2005. So 2000, it's prior to 2006
Oh,
amendment.
prior to 2006 7.
That's why, Lord, I was trying to read the original, Lord, section 21 and 22.
Oh.
Perhaps, Lord,
22 tallies, whatever you read.
yes, 22 tallies, but 21,
Well, it was something different before 2006. Then we require that book also. We don't have that.
এটা আছে 21 এটা আমাদেরটা এই 2006 এর amendment নিয়ে এটা আছে এটা এই এয়ার ম্যানুয়ালে এটা
Before 2006, it was different. Was it different?
yes Lord. 21 was different.
Then we have to have the pre 2006 book. We don't have that. Chartered account.
I'll give you a lordship, Lord.
No, we were just checking up something. Yes, it was handed over on the last one.
I believe, Lord, a copy
It was handed over. Yes. Yes, yes.
where on receipt of information.
21, the council shall by notification.
That is 2006 amendment. Lord, does it reflect, Lord, in your lordship's
Misconduct.
It starts procedure in inquiries relating to misconduct of members
Yes,
of the
yes.
institute.
Yes.
And
It was
that
handed
is-
over on the last one.
That is the
So we'll proceed on that.
এটা যেই জন্যই তো বইটা এনেছিলাম কিন্তু 2006 Lord, may I place 21, Lord,
Please.
for my Lord's consideration.
Yes.
Says, where on receipt of information by or of a complaint made to it, the council is prima facie of opinion that any member of the institute has been guilty of any professional or other misconduct. The council shall refer the case to the disciplinary committee, and the disciplinary committee shall thereupon hold an inquiry, such inquiry, and in such manner as may be prescribed, and shall report the result of its inquiry to council. If on receipt of such report of the council finds that the member of the institute is not guilty of any professional or other misconduct, it shall record its finding accordingly and direct that the proceedings shall be filed or the complaint shall be dismissed as the case may be. If on receipt of such report the council finds that the member of the institute is guilty of any professional or other misconduct, it shall record a finding accordingly and shall proceed in the manner laid down in the succeeding subsections. Where the finding is that of the member, no, then it's obviously not.
Here it was under first schedule or
It
something.
was mixed. I'll just show your lordship, Lord,
Because first schedule, subsection 4 of section 21 says, in respect of first schedule, opportunity of being heard,
yes.
which is missing in 5, subsection 5.
Yes, but Lord, here the opportunity was
Given.
Was given.
Very
So, Lord, so Lord, the procedure for inquiry is that the council shall refer the case to the disciplinary committee, then disciplinary committee hold the inquiry and then report it to the council, and ultimately council will take a decision. So these are the Lord, stages as to how the inquiry should proceed. Now, Lord, kindly come back to the schedule once. I'll just draw your lordship's attention
Yes, schedule.
to the schedule. Lord, first, Lord, kindly see part 1,
Yes.
which talks about professional misconduct in relation to chartered accountants in practice. Lord, please come to 9 or 8, 9, 11 and 13.
All right.
Accepts a position as auditor previously held by another chartered accountant or a restricted state auditor without first communicating with him in writing. 9. Accepts an appointment as auditor of a company without first ascertaining from it whether the requirement of section 225 of the Companies Act 1956 in respect of such appointment have been duly complied with. Then 11. Engages in any business or occupation other than the profession of chartered accountants unless permitted by the council so to engage. And 13. Allows a person not being a member of the institute or a member not being his partner to sign on his behalf or on behalf of his firm any balance sheet, profit and loss account, report or financial statement. Now, my lord, I'll take your lordships to the complaint. I'm just showing, lord, the
Provisions.
the misconduct that is covered, lord, under Schedule 1. Now, kindly, part 1. Please come to part 3. Professional misconduct relation to members of the institute generally. A member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he includes in any statement, return or form to be submitted to the council any particulars knowing them to be false. And then, Lord, please come to the second schedule, part 1. It says professional misconduct in relation to chartered accountants in practice requiring action by a high court. Kindly come to 4. Express his opinion on financial statements of any business or any enterprise in which he, his firm or a partner in his firm has a substantial interest, unless he discloses the interest also in his report. Now, Lord, with this, may I just take your lordship straight away to the complaint. Complainted father right to. Lord, the complaint, your lordships will find at page. Kindly, my lord, take the affidavit in opposition filed by the Institute of Chartered Accountants. এটা opposition by Institute of Chartered Accountants. Volume, এটা কি ভলিউমে আছে? একটাই হবে, দেখুন।
Chartered accountant
এইটাই বোধহয়। এটা কি? না। By, affirmed by, আমি বলছি। ঠিক আছে। ও, আচ্ছা। তাই হবে কারণ আমার এখানে ভলিউমটা বুঝতে পারছি না। থ্যাংক ইউ, সরি।
কোনটা বলবেন না তো বুঝতে এটা কি এই জিনিসটা পিটিশনটা দিয়ে রাখুন হ্যাঁ which page of that
Lord, starts at page 18, 18A. I don't know, Lord, whether the pages will tally because I think it should.
yes 18A
But this is where the affidavit starts. Your lordships kindly come to paragraph 11, page 25.
25 yes
Lord, kindly come to the B, paragraph B. Or A first. The Calcutta firm apparently has 5 branches as New Delhi, Mumbai, Chennai, Bangalore, and Jaipur. From the records of the institute, it appears that the same registration number has been given to the said 5 branches. Such registration number is such and such, which is also the registration number of the said Calcutta firm at its Calcutta address. Further and fuller particulars of the said 5 branches, so far as they are available presently, are set out in a schedule marked so and so. The complainant shall rely upon a partnership deed dated 1st of April 2002, the annual accounts for the year ending 31st March 2004, the computation of income for the said assessment year, and the statement of the partner's capital account and other schedules, as also the statement under section 44 AB of the Income Tax Act 1961, all relating to Calcutta firms, where are hereto annexed and collectively so and so. Form of the said documents, it will be evident as the complainants contend that there were and are in actual point of fact only 3 partners of the Calcutta firm, being the respondent, his father and his brother. Then, Lord, please come to 11D. Or rather B, C first. Lordships will find it's alleged that the Calcutta firm reports to be a partnership between 14 persons. Then in actual point of fact, it is a partnership of only 3 persons. All other persons supported to be shown as partners are not partners within the meaning of Partnership Act 1932, but merely related to the firm in some other capacity not known to the complainants. Then the documents referred to in paragraph B hereof were all signed by the respondent. Signatures on the statement of particulars under section 44 AV of the Income Tax Act appears to be on behalf of Chaudhary P and Associates, a chartered accountant of Calcutta, who carried the audit relating to the Calcutta firm. The copy of the partnership deed referred to the henceforth will show that the same is only signed by the respondent, his father and his brother. In the computation of income, the partners named are only 3 in number, being the respondent, his father and his brother. Similarly, in the profit and loss account, the allocation of profits amongst the partners is shown as credited to the respondent, his father and his brother only. Again, in the balance sheet for the year in question, the capital accounts refer only to the respondent, his father and his brother, with the addition of the name of the respondent's deceased grandfather only. Kindly see the last 4 lines. These facts show that the constitution of the Calcutta firm as being partnership of 14 partners is a hoax and a piece of so-and-so wholly counterfeit. Then your lordships may, instead of reading this, may I just straight away take your lordships to the documents. The partnership deed, Lord, is at page 106.
Uh, 106 is something else.
Lord, annexure
101.
C, this is annexure C.
101
I am so sorry.
dated 1st April 2022.
Yes.
To 2002. Sorry.
2002.
2002. Yes.
গুলো correct করো 101. Lord, kindly see the names of the partners. Rajendra Singh Lodha. Then Lord, that's the first part. Aditya Vikram Lodha, second part, and Harshvardhan Lodha, the third part. Then Lord, kindly come to clause 4.
Yes.
The profit shall be shared in the following ratio among the partners. The losses, if any, shall also be shared in the same ratio amongst the partners. Then Lord, 54% and Lord, 23. Then Lord, paragraph 5, in addition to the share of profit and losses of the partnership firm, as stated above, the parties shall be entitled to salary at the rupees so and so per month, such higher amount as may be agreed. Then the firms shall have such bank accounts as may be agreed to by the partners. Such account may be operated by each partner individually.
These 3 are the only persons named as partners. So whatever follows is between them.
And Lord, the documents that was relied upon, Lord, basic allegation which I'll take your lordship was that by inflating the number of partners, they were taking more audits than what is permitted under the Companies Act. Because Lord, the institute had issued a circular restricting the number of audit in respect of a partnership firm. Per partner, so many audits can be taken. So that is the main grievance on which, Lord, this complaint was made. That by showing inflated number of partners, they were taking, Lord, more audits than is permissible under the Companies Act. I'll show the provisions also. But Lord, basically, this is what it is. So Lord, the partnership deed is one document which was produced with the complaint. Now, Lord, kindly come to just after the partnership deed.
Yes.
Lord, your lordships will find this is a document. It's a balance sheet. Your lordships,
Yes.
this starts at page, it must be, Lord,
104 in our
4. Yes, 104. Lord, it says Lodha and Company assessment year 2004-2005 and accounting year 2003-4. Lord, kindly see the allocation of profit.
Yes.
Allocation of profit, your lordships will find it is allocation is between the 3 partners.
Super.
And Lord, the next page also, your lordships will find that this is a capital account. It is in respect of these. Then Lord, please also kindly look at page kindly see, it says form 3C. This is page 109.
Yes.
It is, Lord, a statement of particulars to be furnished under section 44AB of the Income Tax Act. As your lordship got that, that's Lord, written at the top.
Yes.
In part B, your lordships will find name of the partners are given and their percentage of
Right.
sharing of profit. Then Lord, please also look at, Lord, these are the documents which were annexed to the complaint. Look at 121, 116.
Yes, 116.
Lord, 116 at 117, your lordships will find this is in Mumbai. At the top, your lordships will find this is Mumbai. As on 31st March 2004. Now, your lordships will find in Mumbai, kindly Lord, come to the next page. At the bottom, there were 4 partners.
Yes.
Here in Mumbai, they show there are 4 partners. At the bottom, Lord, of page 123, 118, at the bottom,
Yes. Yes.
there were 4 partners.
The balance sheet also 4 partners were named.
For Mumbai. For Mumbai, there are 4 partners. So for Calcutta, there were 3. For Mumbai, there were 4. And the next page, your lordships will find the profit that is Lord shared between the 4 partners. That is 119, 119.
Yes.
Then Lord, New Delhi, that starts at 120, I think. 120. Your lordships will find at the top, Lodha and Company, New Delhi.
No, that's
Sorry,
Mumbai.
121. 121.
121. 121 is Mumbai.
That starts, Lord, the Delhi comes. And in Delhi, kindly, Lord, see, here also there were 4 partners. Your lordships will find RB Lodha, AV Lodha, HV Lodha, and NK Lodha.
Yes.
And Lord, we also, Lord, annexed with our complaint at page 132.
One three two is
132 is annual report of account
yes, and account.
in respect of Vindhya Telelinks Limited.
Yes.
Because one of our allegation is that while being a director, he having control on the financial control, he was also appointing auditors in respect of companies where he had equal administrative control. That was one of the grounds of challenge that we had made. I'll show your lordship's complaint. And the fact that he was, Lord, as a chartered accountant involved in commercial activities.
He means Harshvardhan.
both Harshvardhan and the father. They were chartered accountants. They were involved in commercial issues. I mean, the companies in which they have substantial control. They had commercial interest in those companies, but they were also not. This was not informed to the institute. But institute did not go into these issues. I will only restrict myself to the issues that the institute. I have made a complaint, but the institute has looked into only 3 complaints. I'll show your lordships to that. But Lord, basic contention was that Lord, they had inflated the number of partners than the actual partners who were shown in the partnership deed, and by reason thereof, they had secured more. Lord, that's the main plank of our attack. ठीक है. I'll come back to this. So, Lord, kindly now come back to paragraph 14 of the complaint. Paragraph 14 is page, same page. Okay, that is paragraph 14 is page, kindly give you one. (35). Yes. The complainant further states that the names of 14 persons as partners of Calcutta firm with its 5 branches has been furnished to the institute with false and fraudulent and mala fide motive. The object of giving such wrong data was inter alia to project an impression that Calcutta firm and its branches were and are entitled to undertake both statutory and tax audits of companies far beyond the limitation prescribed in section 224 of the Companies Act 1956 and the notification issued by the institute more fully mentioned hereinafter. So, Lord, this is one grievance. Please come to paragraph 17, page 37. The complainant states that for exactly similar wrongful purpose, the names of persons who in reality are not partners have been shown to be partners in the Mumbai firm, New Delhi firm, Chennai firm, and Jaipur firm. Furnishing of particulars in respect of these 4 firms, whereby the number of partners are inflated, was also done in order to circumvent the provisions of section 224 of the Companies Act. Then, Lord, your lordships may, this is Lord on the ground of obtaining Lord more than what is permissible insofar as audit is concerned. Then, Lord, kindly come to signing of balance sheet, that is paragraph 21. Paragraph 21 is page 41. The complainant state that clause 13 part 1 of the first schedule to the Act mandatorily enjoins that a chartered accountant shall be guilty of professional misconduct if he allows a member of the institute not being his partner to sign on his behalf or on behalf of his firm any balance sheet, profit and loss account, report or financial statement by showing the names of various persons ostensibly as partners in the said 5 several firms. The respondent also used their services to have them sign balance sheets, profit and loss account and financial statements on his behalf. The complainants call upon the respondent to make full discovery and disclosure with regard to the audited reports and financial statement on behalf of the said 5 several firms in respect of the clients for the last 5 accounting years.
So these other persons are the other partners out of those 14.
Out of those 14, Lord, apart from the Calcutta firm, even in Delhi and Lord Chennai,
Yeah, 4.
Apart from those 4, they were showing
Others were there.
others also as partners.
So 14 minus 3 or 4, those extra partners were also signing. So if those are not partners,
Those,
but
they could not have signed, and that's a violation of the chartered accountant.
the other one,
the
other
chart-
provision.
So that is one. Then, Lord, come to paragraph 22 and 23. This is with regard to violation of section 226(3) of the Companies Act. The complainants further state that under section 226(3) of the Companies Act 1956, it is expressly provided that a person shall not be qualified for appointment as an auditor or a company if he is a partner of an officer of the concerned company. This is the conflict of interest issue. Furthermore, under Part 1 of the second schedule of the Act, it is provided that a chartered accountant will be guilty of professional misconduct if he expresses his opinion on financial statements of any business or any enterprise in which his firm or a partner in his firm has a substantial interest unless he discloses the interest in his report. The respondent is also guilty of violating the aforesaid mandatory provisions as will appear from the facts stated herein. In or about 1998, the respondent, and in or about the year 2001 and 2004, the respondent's father became the directors of the two companies, namely Vindhya Telelinks Limited and Universal Cables Limited, respectively. So and so. The respondent's father, in fact, was a co-chairman in both companies since 5th of May 2004. At all material times, there was a third company named Birla Ericsson Optical Limited, hereinafter referred to as so and so. This company was promoted, incorporated, and established by and at the instance of so and so, and is a company under the same management with the meaning of the Companies Act. All the three companies, namely VTL, UCL, and so, were part of the group of companies commonly known and described as MP Birla Group companies. At all material times and until the financial year 2003-04, the Delhi firm aforementioned was the statutory auditor of BEOL. It is necessary to reiterate in this context that the partners of the Delhi firm admittedly include the respondent, his father and brother. In other words, Lodha and Company were the auditors of BEOL, which was a company, the management of which was in the hands of the respondent and his father. Kindly come to F, page 44. It is a settled principle that one of the primary objects of auditing is to apprise the members of the public and all shareholders about the true financial position of the accounts being audited, and in this behalf the statutory auditors owe a duty of care to the shareholders of the concerned company. The statutory auditors are more the watchdogs of the shareholders rather than the employees of the concerned company. The complainants say and contend that in acting as the statutory auditors of BEOL of the Delhi firm, by the Delhi firm, was guilty of gross dereliction of duty and violating the norms of professional conduct within the meaning of the Act. So, my lord, these are broadly the allegations, and two more, my lord, paragraphs. Kindly come to paragraph 31. 31 to 52, page 52. 31D, page 54. The complainant reiterated that under the provisions of the said Act, without prior sanction from the institute, the respondent had no right whatsoever to engage in any business or occupation other than the profession of chartered accountant. In reality, the respondent was not merely a director simpliciter in any company. He was at the helm.
It's not telling.
I'm
31,
so sorry.
31D.
This is paragraph 31, Lord, starts at page 52.
54 in our
Oh, sorry. Then, Lord,
para 31, we are at para 31.
yes, kindly come to subparagraph D.
D in our copy starts with the complainants
Yes.
state that during the same period.
Reiterate that under the
Reiterate is not there. Something else.
Oh, is this the last paragraph of?
No, last paragraph is.
তাহলে তো আমাদের এটা ঠিক নেই.
There is no reiterate in any of the
I see.
clauses of para 31.
Oh, then Lord, come to para 35. It says that the complainants therefore state and contend. I'm so sorry, my lord.
35 is which page in your?
In my page 56. Internal page 39.
Internal page 39. That's a
Can't be
continuation
different
para
content.
32 in our.
I'm so sorry.
Lord,
Lord,
I hope this is. But till now it was telling. The other page numbers are telling.
Yes. The complainants therefore state and contend that the respondent along with his father was engaged on a full-time basis in an executive position.
Which paragraph is this?
Paragraph Lord 35, but I'm surprised because this is a complaint, Lord. This shouldn't.
35, paragraph 35 at page 76.
FC is your lordship looking at FCA 5? 6.
Oh.
SCA 6.
But it doesn't matter, my lord. It should be the same because it is a complaint. There can't be any.
Yes.
Doesn't matter. ঠিক আছে.
SCA 6, the corresponding paragraph has to be looked at.
Lord, I'll just try to find out. 35 এর এটা আছে affidavit-টা একটু দেবেন আমাকে? Just kindly give me 1
Yes,
minute.
yes, absolutely.
35 এর যে affidavit-টা Chartered Institute-এর FCA 5 হ্যাঁ। Paragraph 35 টা 31 D-টা paragraph 30
না, ওটাতে
31 D-টা but I find that there is some in the there were 2 complaints must have been there paragraph wise there is some problem here. It doesn't matter, my lord.
Submitted in terms of ACA 5 or 5.
But in paragraph 31D,
SCA 5, এটা অন্য।
yes,
ওটা হচ্ছে এটা 6 দেখছি।
They also relied upon ACA 5.
I'm so sorry, my lord, without checking which
No, no, but এটা কাদের? আমাদের কোর্টের?
in substance, my lord,
হ্যাঁ, হ্যাঁ। আচ্ছা, তাহলে এটা এই যে হচ্ছে অরিজিনালটা হারিয়ে গেছিল ওদের।
but in substance it is the same, maybe one paragraph here and there, but I'll try to find out, my lord, from the other one. But in the meantime, may I just 31D, which is not which should be in page 50.
Complaints, here the complaint is actually reiterate.
Let 31D and 35, these are the 2 paragraphs which deals with that without the prior sanction of the institute, they could not have engaged in any business or occupation other than the occupation of being a chartered accountant. These are the allegations, Lord, basically on which. Now, Lord, kindly, Lord, take the report of the council now, the order passed by the council, because, Lord, I am not taking your lordships through the report of the disciplinary
Because that is merged in.
because that's merged there. So, Lord, I'll just straight away take your lordships to the order.
That will be in the main petition.
Main petition. I'll just give your lordship the page. Decision of the council. It starts at page 82.
Petition.
Dated 16th.
এই তলাটা main petition.
16th May 2022. This should be in main appeal. Look, the other briefs can be
Put aside for the
yes,
time.
because this is the main thing which on which Lord it's a common order that has been passed in respect of both.
Page 82 it starts, yes.
83 it starts.
83 actually, yes.
Lord, if your lordship straight away come to page 100. Kindly, my lord, come to page 97. Sorry. which gives an overview of what the disciplinary committee held.
Yes.
97, paragraph 4. The disciplinary committee conducted the inquiry in the case hearing in matter was completed in its meeting date such as a disciplinary committee submitted the report dated 3rd February 2010 with the following conclusion. Charge number 1 held guilty. But 2 and 3, paragraph 4.2, 4.1 is charge number 1 held guilty.
Yes.
Charge number 1 held guilty, charge number 2 and 3 not guilty, charge 4 guilty, charge 5 not guilty, 6, 9 and 10 guilty. So charge 1, we are concerned with charge 1, charge 4 and charge 6, 9 and 10. The others not guilty. Now, my lord, discussion on charge 1 starts at page 100.
Yes.
Lord, 5.1.1.
Yes.
The photocopies of all documents filed by the complainants, that is partnership deed, annual accounts, tax audit report, income tax computation and returns in income, etc., clearly show that there were only 3 partners in Lodha and Company Kolkata, 4 in each of Lodha and Company Mumbai and Lodha and Company Delhi during the financial year 2003-04. However, as per Form 18 furnished by the respondent and constitution certificate issued by ICAI along with other words, the number of partners in Lodha and Company Kolkata was 14, in Lodha and Company Mumbai 8 and in Lodha and Company Delhi 5. So, my lord, Form 18 is what they filed with the Institute of Chartered Accountants. On a perusal of Form 18, Constitution Certificate, Mrs. Lodha and Company Partnership Deed, Empanelment Form, Balance Sheet and Income Tax Return of the firm, the committee has observed as under, in case of Lodha and Company Kolkata, this is the profit sharing ratio, etc. These are the position. Then, Lord, I won't trouble your lordship with this. Please come to page 107. After all this discussion, or rather, kindly come to page 104 first, 5.1.5. Though the respondents have submitted that Form 18 filed by them with Institute is itself a certificate of partnership, however, on perusal of Form 18, Lodha and Company Kolkata, along with copy of the income tax returns for the assessment year so and so, filed by the respondents with the Institute, it is seen that Form 18 on one hand shows 14 partners, whereas per balance sheet as on 31st March 2001 filed by them, they have shown only 3 partners. Further, as per Form 18, Lodha and Company Mumbai filed by the respondents along with the copy of the returns filed for assessment year 2001-2 with the Institute, it is seen that Form 18 shows 8 partners, whereas as per balance sheet as on 31st March 2001, it shows only 4 partners. Then 5.1.6, the committee was not able to appreciate the argument of the respondent counsel to ignore these documents only on the ground that the complainants have not disclosed the source of their procurement or that these are misappropriated or illegally procured documents. The committee was of the view that since it is a matter of dispute about the number of partners in the firm on the basis of the details filed by the respondent in form number 18 along with balance sheet and income tax papers submitted and the photocopy submitted by the complainants and also as agreed by all the partners in writing that they were the partners and also the empanelment of the form signed by all the partners as and when it was mandatory, which brings to the conclusion that there was wrong particulars filed either with the institute or with the income tax department. The arguments of the respondents like empaneling authority, CAG and RBI have not raised any issue about their partnership did not appear to be convincing. It is neither possible nor justified to place reliance on documents shown to the disciplinary committee by the respondents during the course of the proceedings, as none of such documents or any copy thereof were filed either before the council or the committee, nor no opportunity was also given to the complainants to offer their arguments on such documents. So, my lord, this is one of the questions that my lord posed, that what document did you submit from the or the appellant? Lord, this is the analysis of what the document they wanted to show to the committee.
What is the document? The documents are not mentioned. It's
The documents are not mentioned. It says that the documents shown to the disciplinary committee by the respondents during the course of proceedings, none of such documents, any copy thereof, were filed either before the council or committee, nor opportunity was given. Lord, since the
Just
copies were
shown,
not
handed over.
handed over. But Lord, since the copies were not given to us, we had no opportunity, and it was not filed. Therefore, Lord, we had no opportunity to even look into these documents. What are these documents on which they want to rely on? But the principal fact is that the balance sheet and the partnership deed, they were not disputed. It was not their case that these documents that we have submitted, they are not the original documents.
They're only on the mode of proof because those were procured.
Procured. How this is procured? This is
Substance, those were not disputed.
Not
and these
disputed.
are not correct documents.
Absolutely. Absolutely. Now, Lord, 5.1.8, the respondents contend that it is not essential to share the profits on a percentage basis, and a fixed remuneration can be paid to the partners. Lord, this is one of the basic argument which was advanced, that these partners, they need not be shown, even if the remunerations are paid to them, that is sufficient. That's being dealt with. They have cited certain case laws. The committee carefully noted the facts of the present case are different from the case cited. In the case cited, it is clear that there was an agreement between the parties and the fixed remuneration was in lieu of profits. Kindly, my lord, mark this.
Yes.
In the present case, the agreement is between three parties only, and the remuneration paid to the others was not in lieu of profits or out of profits. Rather, it was a charge to profit. Now, Lord, I just pause here for a moment. Lord, the partner gets his share of profit. The profit has to be assessed, Lord, after taking into consideration the income, the expenses, and Lord, after tax, etc., then the profit comes. And then there is a question of sharing the profit. So, Lord, unless there is an agreement to show that some remuneration would be paid to the partners in lieu of their profit, there was no such agreement, Lord, which was brought on record. This is, Lord, becoming an expenditure. This is not a profit. This is what, Lord, is being said. May I just place it once again?
Then if it's in lieu of profits, Mr. Kaur, then even if there is no profit, they won't get that remuneration. The fixed nature of the remuneration is only regarding the quantum. That instead of say 10% profits, I'll get rupees 10 lakh.
Yes.
But I don't get that if there is no profits or something like that.
And Lord, I'll show the Partnership Act also, and Lord, one or two judgments where, Lord, it is categorically said that the agency has to, between the partners, has to be established by a document. That they were carrying on business.
That was another point argued by Mr. Mitro, that for registration of a partnership firm, no document is required.
I'll try to show from the section itself that, Lord, this is elementary. One has to,
because so many procedures cannot be complied with unless there is a document.
Absolutely. And that document is absolutely essential. Otherwise, Lord, how the income tax department at the end of the year, if the share of profit is say X, Y, Z, whatever, the income tax department may also like to look into that document, that whether this percentage which is distributed in terms of the agreement between the partners.
Suppose we don't have an agreement, a document, but still want to get the firm registered. Is it impossible?
It is, because I'll show your lordship the Partnership Act, section 3, 4 and 5. There are three sections, which clearly says, may I just place it, Lord, since this issue has come.
Partnership Act the
Partnership Act আছে আমার আমার Partnership Act the Please, my lord, come to section 4 first.
Yes.
Definition of partnership, partner, firm and firm name, partnership is the relation between the persons who have agreed to share profits of a business carried on by all or any of them acting for all. So, my lord, the first is there has to be an agreement to share profit of a business carried on by all or any of them acting for all. Then, Lord, please come to section 5. It says the relationship of partnership arises from contract and not from status. So, Lord, unless there is a contract,
Need not be in writing, Mr. Court.
but Lord,
We are taking the extreme case in their favor.
very well. Lord, but then this relationship has to be proved from some document. There has to be
Something has to be there at the time of otherwise the profit sharing ratio and everything else cannot
this
be
contract
crystallized.
can be by conduct also. Let us say, Lord, the extreme case
Yes.
that it can be by conduct. But Lord, if it is by conduct, then Lord, it must be reflected somewhere,
Yes.
either in the balance sheet or Lord in some document. Then Lord, please take section 6. Mode of determining existence of partnership. In determining whether a group of persons is or is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. So, Lord, real relationship of the parties, that was necessary for them to bring on record. Filing a form 18 or form 8, whatever the form is, before the Institute of Chartered Accountant, that is not sacrosanct. It was absolutely essential for them to establish the relationship between the parties. Lord, to dispel, Lord, my complaint, they had to bring in some document to show that this profit sharing ratio was not the profit sharing ratio as shown in the balance sheet. It was not their case that these balance sheets are not their balance sheets, not the balance sheets of Lodha and Company. So, Lord, some material evidence was necessary for them to show.
All right.
The adjudicating authority is adjudicating a list between the two parties. I have lodged a complaint that there is a professional misconduct for XYZ reasons. And I have, Lord, given some documents. Apart from how these documents are procured, there is no challenge to those documents. Secondly, Lord, what they are trying to say is contrary to the document.
Then they had to show something to indicate that what is the ratio being, what is the ratio of profit sharing between them
Absolutely.
by some other document, their receipts or their statements, something of that sort.
Or some document where they say, where
Yes.
it is shown that these partners, all of them, they are not, they are actual partners.
Contract has to be, that agreement has to be crystallized somewhere, I mean, by some document.
And Lord, when there is an existing partnership deed, there can't be any other document by which that partnership deed can be jettisoned to show
The
that
existence of the deed has not been
questioned at all.
Did they produce the deed?
No.
And that is one of the documents which they say you have procured.
Yes.
All right.
So, Lord, they could have shown, Lord, in 2005-6 or 2006-7, there has been reconstitution of partnership. That was not their case. They have not produced, Lord, a single document.
There should be some mechanism, Mr. Kaur. If there is a deed, at the time of registration, some copy should be filed with the registrar.
Absolutely.
So you could have also called for them, or they could have.
That was possible, but Lord, if they are showing something different than what we have produced, then only question of our owners comes. We have produced a document and the balance sheet which are signed by them. These balance sheets are signed by the partners.
How you obtained the documents, you have been shy on that.
I have not mentioned that, but Lord, the law is very well settled. If the genuineness of the document is not an issue, then Lord, how I have procured it is immaterial. I got that judgment, but I don't think it's so elementary. I have to show that. But Lord, within the scheme of the Partnership Act, Lord, there has to be some contract, some agreement to show that there exists an agency as between the partners or existence of some relationship between these partners to share profit. All right. Now, my lord, may I just go back to the order that I was placing?
But Partnership Act should be changed by introducing written contract. Otherwise, it will be very difficult for any authority or court to decide ultimately.
Lord, the point is that, Lord, the Partnership
Something
Act
must be there in
also
writing.
contains, Lord, a section where it says that unless the document is registered, partnership
Document need not be registered.
the partnership itself.
That's the difficulty, Mr. Kaur. The document need not be registered. That's what people have been arguing for ages, at least since 1932. The
69,
that
69
registration not of the deed but of the firm.
Firm.
So that's quite all right, but has to be backed by some this sections 4, 5, and 6 should introduce the term written. Otherwise, this will go on happening.
contract.
The contract, preceding contract, it should be written contract in writing or something like that. Should be there. Anyway.
So, my lord, your lordships may kindly, Lord, come to now page 107. 5.1.12.
Yes.
The respondents could not produce any partnership deed in support of their contention in Form 18 under serial number 3C, whether the partnership is supported by a deed, to which the answer was yes. Answer was yes. In view of the aforesaid, the committee was of the considered opinion that the respondents were responsible for filing false particulars of partnership of Messrs. Lodha and Company, Mumbai, etc. And then let kindly come to the last two paragraphs. Accordingly, the committee was of the opinion that the respondents were guilty of professional misconduct falling within the meaning of clause 1.
So they did not produce any document.
No.
Form 18 was also produced by you.
No, Form 18 was produced by them.
By them.
Form
So that
18
says yes.
Form 18 showed that not there are a number of partners, but that has to be matched with some other document.
No, in Form 18 also it was stated whether there is a partnership is supported by it. They
Say
say
yes, but
is very
that
crucial.
deed was not produced.
Yes.
So, my lord, that's why I say that, Lord,
Right.
there was no onus so far as we are concerned. Then, Lord, please come to page 118. Clause, paragraph 8.1.1.
Yes.
The Income Tax Department had passed an order dated 10th March 2011, wherein it had reassessed tax of Lodha and Company, Kolkata for the assessment year 2004-5.
Yes, please.
The assessment was done by the department after several hearings were held in the matter. By this order, the Income Tax Department added back the amount of salaries paid to the salaried partners of the firm, amounting to rupees 77 lakhs, etc., set off against expenditure and not taken into account while calculating allowability of the remuneration payable to partners under Section 40B of the Income Tax Act. The Income Tax Department, after examination of various documents, including the partnership deed dated 31st December 2001, which refers to all 14 partners, and subsequently partnership deed dated 18th December 2003, by which the number of partners increased to 17, the role played by the partners, nature of relationship amongst them, and explained all the persons named in the said deed as partners, has proceeded on that basis. Accordingly, in terms of the reassessment order, there remained no deficiency furnished in form number 18, and on that basis, all the income tax assessment for the relevant period have been done. Now, my lord, I pause here for a moment. This was the argument advanced producing the order of the income tax assessment department, which was passed in 2011, where, my lord, they added back this expenditure, and this adjustment was allowed by the income tax department. Now, my lord, please come to 8.1.2. Mrs. Lodha and Company has been applying for empanelment of bank audits year after year to the institute. As per the requirements of empanelment, copies of income tax returns along with copies of final accounts returns of all partners were attached as part of the application. Not only the income tax returns of firm, but income tax returns of each partner also was along computed annexed to the said firm. Then, Lord, CAG empanelment, that is also stated at paragraph 8.1.3. Then, Lord, please come to, after all this, 8.1.5. 8.1.5 starts at page 120. The council further noted that the complainants did not submit anything with respect to this charge. The complainants council at this time of consideration of the report by the council further submitted that all the charges wherein the disciplinary committee has held the respondents guilty of professional and on other misconduct, they are accepting the disciplinary committee report and have nothing further to mention in this regard. At the time of consideration of the report by the council for the respondents reiterated what has been submitted in the written submissions by the respondent and further submitted that there is an agreement by the partners in a partnership firm, and out of the profit so on, some of the partners were drawing remuneration on fixed basis. Then, Lord, please come to page 121. Around, Lord, 8 lines from the top, 8 or 10, Lord, your lordships will find it was observed. Oh, sorry. Yes, it was observed that return of income, it was about 4 or 5 lines, sorry.
Got it. Yes.
It was observed. This, kindly come, Lord, I'll read the sentence from the council, 3rd line. The council also perused the assessment order which was filed by the respondent along with their written representation. On perusal of the assessment order, it was observed that the return of income for the assessment year 2004-05 was filed by the assessee firm on 1st November 2004, showing the total income of so and so. Assessment was processed under 143(1). The same was rectified under 154 of the Act. It was also observed that the approval of reopening of the said assessment under 147 of the Income Tax Act was sought from additional CIT range 54. The additional CIT Kolkata, via his letter dated 9 February, gave the necessary approval. It was noted that the remuneration paid to these partners who were drawing profits on percentage basis was considered by the assessee for the purpose of calculating limit under section 40B of the Income Tax Act 1961. The remuneration paid to the other partners drawing remuneration on fixed basis has instead been claimed as expenditure allowable under section 37 of the Act. They have to be dealt with as per provisions of section 40B of the Act. Accordingly, the amount of claim for partners' remuneration available under 40B needs to be recomputed. Accordingly, the income of the assessee firm was recomputed and additional demand of so and so on the assessee was made. So, my lord, this was what was allowable, that was recomputed and added back with an additional income tax liability. And then, Lord, please come to the concluding paragraph 8.1.7. 120. In this context, the council was of the view that the fresh evidences which has been so brought on record by the respondents are the assessment orders relating to the assessment year 2004-05. The limited purpose of these assessment orders is only from the angle of revenue collection by the department, whereas the proceedings before the disciplinary committee, the matter before the council are separate sets of proceedings, and the assessment order so passed by the income tax department does not have any bearing on the matter which is before the council of the institute, which respect to the number of partners of the firm. In this context, the council further noted that the respondents had brought on record before the income tax department partnership date dated 31st December 2001. Whereas if the respondent have relied upon this so-called partnership date, then accordingly the same should have been placed on record by them before the committee. and if not so, before the committee or at least before the council for coming to its independent opinion. The council further noted that the returns which had been endorsed by the respondents about the income tax returns filed by the so-called partners are concerned. It was categorically seen that some of the so-called partners, while filing their income tax return, had shown their income as salary from the firm, and in support of this, even the salary certificates were also enclosed along with the copy of the return, which further strengthened the fact that these so-called partners were in fact drawing salary. It was also observed by the council that though in form number 18 filed by the respondent under serial number 3C, that is, whether the partnership supported by deed, which the answer was yes, however, the respondent at no point of time produced the said partnership deed, which they have produced before the income tax department. Accordingly, the council accepts the report of the disciplinary committee insofar as respondents being responsible for filing false particulars of partnership messes below the head company. So, Lord, basic point is that they said, they took a point by producing the assessment orders that they had produced certain partnership deed before the income tax department. But those partnership deeds were not produced before this authority. And they relied upon Form 18. Now, Form 18 and the document produced by us of 2002, this is 2001 they are relying upon, 2002, which clearly showed that, Lord, there were four partners in three partners in Calcutta and the four partners in Delhi and Mumbai, and Lord, 5 partners in Jaipur. So this is, Lord, the finding on the charges of wrong, Lord, information being given. This is, Lord, charge 1. Now, Lord, I come to charge number 4, which starts at page 125.
Yes.
The respondents rebutted the decision of the disciplinary committee with respect to the aforestated charge and submitted as under. Lord, in so far as charge number 4 is concerned, we'll just kindly keep a note that the disciplinary committee's finding is contained in paragraph 5.3.1 to 5.3.4 at starts at page 109. Page 109. It's your lordship have to go back. 109.
Oh, achha.
What has happened is the council has set out, Lord, the finding of the disciplinary committee, and then, Lord, has given its own finding.
Right.
So, Lord, the own finding starts insofar as charge number 4 is concerned at page 8.3 at 125.
Yes.
The respondent rebutted the decision of the disciplinary committee with respect to the aforestated charge and submitted as under. The respondents emphasize that both CNAG and RBI are statutory authorities, and judgment of these authorities as to whether certain information filed by them was true or untrue deserves to be respected by other similar authorities. The respondent further submitted, Lord, I skip the submission. Please come to the finding 8.3.2.
Yes.
The council took into consideration the submissions made by the respondents with respect to this charge, along with the report of the disciplinary committee, and further noted that since the respondents and their firms have filed different sets of papers before different authorities, moreover, the respondents have failed to bring in record as to what papers they have filed before the other authorities. Since the said information was withheld, their personal knowledge personal knowledge, and thus the onus to prove the same rested with the respondents, which they have failed to do so. Accordingly, the council accepted the report of the disciplinary committee and held that the respondents guilty of professional misconduct, falling in terms of clause 1, part 3 of the first schedule to the Chartered Accountants Act 1949, read with section 21 and 22. Lord, if your lordships kindly look at clause 1 of part 3 once. Part 3 of the schedule. professional misconduct in relation to members of the institute generally. Yes. A member
Yes,
of
yes,
the institute, whether it in practice or not, shall be deemed to be guilty of professional misconduct if he includes in any statement, return or form to be submitted to the council any particulars knowing them to be false. So, Lord, this is charge 4. And so far as charge 6, 9 and 10 is concerned,
but this is to be submitted to the council.
to the council.
But they submitted those before the income tax.
No,
authority?
Form 18. Form 18.
Form 18.
Lord, they are only concerned about Form 18. Income tax department, Lord, they are really not concerned. They are saying that corroboration of the documents that was filed before the income tax department did not happen before us. And they are thus, Lord, they are only comparing between the partnership deed that
Deed
we
and
filed
18.
and the other documents that we have filed and, Lord, the Form 18. This is what the finding is. They are not, Lord, really going into what the other authority has accepted. Obviously, it's none of their business. Lord, 6, 9 and 10, if your Lordships, Lord, kindly come to,
Yes.
finding is starts from page 129. Or rather, Lord, if I may just place page 127 onwards.
Yes.
The council noted the submissions made by the respondents with respect to the report of the disciplinary committee, which are as under. There were 9 subscribers to the Memorandum Association of BEOL, UCL and VTL. This is those 2 companies, Lord, where those 3 companies were not subscriber to Memorandum Association. Admittedly, CA Harshvardhan Lodha, late Sri Rajendra Singh Lodha and Lodha and Company and its partners were not shareholders of BEOL, and none of them has held any post of director or any office of BOL up to the year 2003-4, which was the year under question in this case. In the annual reports of UCL and VTL, it was clearly mentioned that late Sri Rajendra Singh Lodha and CA Harshvardhan Lodha were in the management of any of these said 2 companies. CA HV Lodha was appointed as director in VTL only in May 2004, which is after the period of audit of BOEL. Messrs. Lodha and Company never audited the accounts of UCL, VTL or BCL. The link between BCL and Harshvardhan Lodha and Mrs. Lodha and Company or any partner of Lodha and Company was not by way of substantial interest in BCL, but by virtue of the respondent number 1, Harshvardhan Lodha being a director, that to a non-executive and independent director of BCL during the financial year 2003-4, by virtue of VTL and UCL, together owning 26% of the paid-up share capital of BEOL, the respondent number 1, CA Harshvardhan Lodha, does not become the owner of such shares or become a person substantially interested in the company. Then, Lord, 4, a single director, CA Harshvardhan Lodha, that too as an independent non-executive director, UCL and VTL, could not be in a position to control the influence the board of BOL, more so when he was not even a director of such company. On the other hand, it is the admitted case of the Birlas as well as the complainants that Srimati Birla was in control of the companies forming part of so-called MP Birla Group during her lifetime. Then, Lord, please come to page 8 clause 8.5.2, page 129. Upon consideration of the submissions and the documents on record, the council noted as under. The council noted that the respondent number 1 held 100 shares of BRL till July 2002, whereas the amendment in section 226(3)(e) prohibited holding of any security by the auditor came into force with effect from 13 December 2001. Accordingly, there was violation of section 226(3)(e) of the Companies Act 1956. The council also noted that BOEL and BRPL were part of MP Birla group of companies and VTL and UCL were together having substantial interest and even control over BEOL. Late CA RS Lodha and the respondent number 1 were directors in the said 2 companies, VTL and UCL, and various other companies under the same management. These 2 companies are the promoter companies of BOEL and together held 26% of the equity therein. Control the exact number of directors therein, appoint managing director therein, nominate chairman of the board, and the quorum of the BOD is majority of directors nominated by these 2 companies. The council further noted that the appointment of statutory auditors is done at the AGM with the approval of the shareholders of the company, that is BEOL, of which VTL and UCL were holding 26% shares. Since the respondent number 1 and his father were directors in the said company, accordingly they were instrumental in appointing their own firm as statutory auditors of BEOL, which in clear terms shows the conflict of interest. The council also noted that the respondents and their father were very closely associated with the promoters of MP Builder group of companies, where at the helm of affairs of the group companies held several positions in the board committees and key positions as vice chairman, etc. The council also noted that these were the admissions which were made by the respondent before various courts of law. The council also noted that Lodha and Company were the auditors of Birla Ready Mix Private Limited, and respondent number 1 was the director of Birla Corporation Limited, which had promoted the former company. The respondent's father was also appointed as the vice chairman of Birla Corporation Limited. The council also noted that the Companies Act prohibits acceptance of audit by a director of holding company and shareholders of the company under audit, and in the present case, UCL and VTL were having substantial interest and were controlling the board and management of BOE. In this context, the council noted that if the opinion of the auditor is to comment and respect the confidence of the public, it is essential that they must disclose every factor which is likely to affect their independence. Then, Lord, please come to the last 4 lines. Sentence starting with the word, since the respondents
Yes.
were fully aware of their interest and their effect on the independence while accepting and conduct of audits of BOEL and BRPL, yet they failed to report their interest in the promoting companies. Accordingly, the council accepted the report of the disciplinary committee and holding the respondents guilty of professional misconduct with respect to the aforesaid charges as given therein. So, my lord, this takes care of 6, 9 and 10.
6, 9. Yes. You just take that break.
Yes, my lord. Yes.
Continuing matter.
Just to summarize, Lord, the three allegations which has been upheld
Yes.
by the institute are inter alia inflated numbers of shown as partners.
Yes.
Second is, Lord, with regard to wrong disclosure in Form 18. And Lord, third is conflict of interest. These are the three charges which has been upheld.
Wrong information and allowing other persons to sign.
Form 18.
Form 18 covers that.
Covers. And Lord, insofar as conflict of interest is
Yes.
concerned, that was the last finding which I placed. Now, Lord, on the penalty, I don't want to, Lord, make any submissions because it is for the institute to decide once the misconduct is proved, Lord, how the institute wants to deal with it. In fact, in respect of one, if your Lordship sees the operative part, which starts at page 139.
Yes.
Which is the minutes, this decision of the council, ultimate decision, the Lordships will find that they say that the council kindly see the recommendation at page 140. In respect of para A and C above, the council decided that an opportunity of hearing under section so and so Chartered Accountants Act be afforded to the respective respondents, namely CA Aditya Vikram Lodha and CA Harshvardhan Lodha, before passing orders against them. In respect of para A above, the council also decided to recommend to the High Court that the names of both the respondents, namely so and so, be removed from the register for a period of 6 months.
That recommendation is not before us.
That recommendation is also before your Lordship, I believe.
Within this bunch of matters.
No, that's a
That must be a different.
See institute file.
This is the challenge against that.
I think CA Institute has
Yes.
forwarded that, but
Anyway, not assigned to us.
I really do
Is
not.
there only the challenges by the?
Yes, by us.
Yes. So, Lord, I say that.
Anyway, if this goes, that also goes.
Yes.
And
And
if this is written, then that will
Then
take
that
its
is-
own course. Yes.
that will take its own course. And in any event, Lord, I am only concerned about a professional ethics and maintenance of professional standard. I am not going beyond that. And so far as the penalty that has been prescribed, Lord, I leave it to the institute and Lord, this honorable court, Lord, whatever your Lordship feels, that's one aspect of the matter. But Lord, on
Section 21(4) opportunity of hearing, this is on sort of sentencing.
yes, on the sentence. So, Lord, this is what the matter is all about. Now, Lord, I want to take your Lordships through some of the sections of the Companies Act, just two.
Yes.
Because, Lord, that repeatedly, Lord, the institute has said that there is a violation.
56 Act.
1956 Act. Ache ki?
Yes.
Lord, two sections, kindly take section 224 and section 226. Lord, 224 first.
Yes.
Appointment and remuneration of auditors. Every company shall, at each annual general meeting, appoint an auditor or auditors to hold office from the conclusion of that meeting until the conclusion of the next annual general meeting, and shall within 7 days of the appointment give intimation thereof to every auditor so appointed. Then provided that before any appointment or reappointment of auditors is made by any company at any annual general meeting, a written certificate shall be obtained by the company from the auditor or auditors proposed to be so appointed, to the effect that the appointment or reappointment, if made, will be in accordance with the limits specified in subsection 1B. Now, Lord, 1B. On and from financial year next following the commencement of the Companies Amendment Act 1974, no company or its board of directors shall appoint or reappoint any person who is in full-time employment elsewhere or firm as its auditor, if such person or firm is, at the date of such appointment or reappointment, holding appointment as auditor of the specified number of companies or more than the specified number of companies. So, Lord, this was
This is on the inflation.
inflation. This is on the inflation. And then, Lord, please come to 226. There's disqualification of auditors. It says a person shall not be qualified for appointment as auditor of a company unless he is chartered accountant within the meaning of the Chartered Accountants Act, provided that a firm whereof all the partners practicing in India are qualified for appointment as aforesaid may be appointed by its firm, so and so. Kindly come to 3. None of the following persons shall be qualified for appointment as auditor of a company. It says an officer or employee of the company, a body corporate, officer and employee of a company. And then Lord 4, a person shall also not qualified for appointment as auditor of a company if he is, by virtue of subsection 3, disqualified for appointment as auditor of any other body corporate which is that company's subsidiary or holding company or subsidiary of that company's holding company, or would be so disqualified if the body corporate were a company. This is not the restrictions on conflict of interest.
Right.
And Lord, a director is an officer of a company. Your lordships will see the definition. Kindly give me 1 minute, I think, section.
It says director is a director.
Director is director. No, Lord,
Basically, director is a director. Any person occupying the position of a director by whatever name called. So it's like a rose.
but Lord, if there is an offense which is committed by a company, for
Yes.
example, Lord, non-filing of returns in time, etc.,
Yes.
it is the directors who are, Lord, responsible.
Yes.
In any event, Lord, it's on the anvil of conflict of interest.
He becomes an officer of the company.
Officer of the
Definitely.
That
Should
is that is what I'm saying.
be. Mr. Kaur, under the Chartered Accountant Act, violation of sections 224 and 226 of Companies Act per se is not an offense.
No,
But it comes within the ambit of that by
Yes,
virtue of
because-
those provisions.
because Lord, it is a professional misconduct.
This shows the eligibility, and if that is violated, that's a
That
professional
is
misconduct.
professional misconduct. Now, Lord, just first point that Lord, whether in a partnership
Yes.
a document is necessary,
Yes.
and Lord, whether Lord, sharing of profit in respect of the partnership and the agency
Yes.
should be culled out from an agreement between the parties.
Right.
That is these issues, Lord. I first cite a judgment which is reported in 1987, volume 3. 1987, volume 3, SCC, page 538. Lord,
আপনি বলুন এটা মিস্টার করকে বলুন আপনার পার্টিসিপেশন থাকবে হ্যাঁ বলুন বলুন
Lord,
Director comes under the heading of officer as per the
definition.
definition of officer
Yes,
includes that.
Right.
That is
that's what I wanted.
30.
213. Lord, actually, I said that, but since it fell from Justice Bhattacharya, I didn't have the courage to show it in the section because he says obviously he's an officer. So I didn't have the courage to show it, but under the definition, he's an officer. Lord, if your lordships kindly come to paragraph 5 first. The main question in issue in this appeal, as well as before the High Court in revision, was whether there was a genuine partnership at all in which the appellant was a partner. It is true that since after October 4, 1960, the partnership firm was carrying on business in the premises in question. It is well settled that if there was such a partnership firm of which the appellant was a partner as a tenant, the same would not amount to subletting leading the forfeiture of the tenancy. For this proposition, see the decision, etc. Thakkar J of the Gujarat High Court, as the learned judge who then was, held that the mere fact that a tenant entered into partnership and allowed the premises being used for benefit of partnership does not constitute assignment or subletting in favor of the partnership firm. Now, my lord, your lordships may kindly come to paragraph 11. 8 first, sorry. 8. Whether there was a partnership or not may in certain cases be a mixed question of law and fact, in the sense that whether the ingredients of partnership as embodied in the law of partnership were there or not in a particular case must be judged in the light of the principles applicable to partnership. The first question therefore is, what is a partnership? That has to be found in section 4 of the Indian Partnership Act 1932. It says partnership is the relation between persons who have agreed to share the profit of a business carried on by all or any of them acting for all. Section 6 of the said act reiterates that in determining whether a group of person is or is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to the real relation between the parties as shown by all relevant facts taken together. The following important elements must be there in order to establish partnership. There must be an agreement entered into by all partners, all parties concerned. Agreement must be to share profit of business. And 3, business must be carried on by all or any of the persons concerned acting for all. The partnership deeds were there entitling the petitioner to share in the partnership. It is true that in the partnership deed, the bank accounts were not to be operated by the appellant, and further that the irrespective of the profit, the clause of the partnership deed provided that there should be a fixed percentage of profit to be given to the partner appellant number 1. Appellant was not to share the losses, but there is nothing illegal about it. The appellant was to bring his asset, etc. Then Lord, please come to paragraph 9. Paragraph 11, sorry. Paragraph 10 talks about the bank account. Paragraph 11, were of the opinion that there were evidence that these terms were acted upon. There was nothing intrinsically wrong in the law in constituting a partnership in the manner it has been done. It was contended by Mr. Mehta that there was no agency reading the partnership deeds as we have read. The conclusion does not emanate from positioning appearing debiting the fixed amount payable to the appellant in the expenses account, which also is not inconsistent with partnership. There is also not inconsistent with the treating the rent of the firm in the context of the total expenditure of the firm. In the event all these factors were considered, then Lord, your lordships may kindly come to paragraph 19 ultimately. In the instant case, the basic question is whether, keeping in background the partnership deeds referred to herein before and the facts that came to light, was there partnership or not? Sharing of profit and contribution to losses were not the only elements in a partnership. Existence of agency was essential, and whether there was a partnership or not is a mixed question of law and fact, depending upon the varying circumstances in different cases. This view was reiterated, etc. And then it says, observe that whether the relationship or partnership between 2 or more persons does or does not exist must depend on the real intention and contract of the parties and not merely on the expressed intention. We also refer to section 4. There must be an agreement. The agreement must be to share.
So we get 2 things from this judgment. One is that an agreement must be there, contract or agreement. And if there are deeds, those have to be looked into.
And Lord, under the document, Lord, a partner can get, Lord, a fixed amount as remuneration.
At least the intention to form a partnership and profit sharing ratio,
Has
to be reflected. If there is no deed, then it becomes all the more difficult. But it has to be proved. The intention has to be proved.
Absolutely.
And here you say Form 18 discloses, yes, there is a partnership deed, they withhold it. You produce a document, they say that's procured, so therefore withholding based evidence is also there, adverse inference, and you produce a document so that could have been looked into.
In fact, Lord, the situation was that I produced a deed of 2002.
Yes.
They say that there is a 2001 document.
Yes, they don't produce.
They don't procure that. Now, they don't produce that.
Yes.
Now, 2001, 2002, they can't exist side by side. One has to exist.
Yes.
Number one. And number two is, Lord, if they have shown the 2001 document to income tax authorities and income tax authorities have acted on them, then income tax, I don't know, Lord, whether income tax authorities were informed that there is a 2002 document. And therefore, Lord,
The 2001 document was not produced before the council or the disciplinary committee.
they're not produced.
If that was produced, if there was mention of 14, that could be dealt with, but they withheld it.
They withheld. So, my lord, best evidence was not produced. Best evidence in their support or in their defense was
Yes,
not
yes.
produced. 2014 SCC online. My lord, to the same effect is the other judgment. Lord, 2014 SCC online Bombay, page 175. Paragraph 12, if your lordship looks into. Lord, this is reiteration of that Supreme Court view. Therefore, Lord, kindly take note of paragraph 12 only.
Yes.
And in fact, this is what was summarized by your lordship. So therefore, Lord, this is by a learned single judge, but Lord, I believe that Supreme Court judgment was noted. ওটা কি সঞ্জয় কানু ভাই ব্যাপার ছিল? হ্যাঁ হ্যাঁ মনে আছে। Lord, the learned judge, Lord, here has considered, Lord, other judgments. Huh? No. 87.3 টা নেয়নি, কিন্তু অন্যান্য judgment consider করেছে। They are mostly, Lord, Bombay judgments which were considered. But Lord, ultimate conclusion is the same. Your lordship looks at paragraph 12, my lord will find the ultimate conclusion is the same. Lord, even if it is a mixed question of fact and law, Lord, to decide the issue, one must have some material evidence. Otherwise, Lord, how can it be decided?
Yes.
And Lord, it can't be said offhand that the view taken by the institute was not a possible view.
Yes.
If it is a possible view,
We won't interfere.
then Lord, whether it calls for any interference. Now, Lord, on the professional misconduct. Lord, it is 2001, volume 6, SCC 135. But this is under section 35 of the Advocates Act, Lord, which has, Lord, a similar language. If your lordships kindly, Lord, I believe the Advocates Act has come.
Yes.
So lordships, Lord, kindly have a look at the Advocates Act, section 35. Right. It is more generalized. It says, where on receipt of a complaint or otherwise a state bar council has reason to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. And then Lord, disciplinary committee will decide. So Lord, basically, professional or other misconduct is not defined. There is no schedule under this Advocates Act as in the Chartered Accountants Act. So Lord, this was considered by the Supreme Court on how this provision needs to be construed. If your lordships, Lord, kindly come to page paragraph 130, page 135, and come to paragraph 16 to 19.
Yes.
The collocation of the word guilty of professional or other misconduct has been used for the purpose of conferring power on the disciplinary committee of the State Bar Council. It is for equipping the Bar Council with binoculars as well as whip to be on qui vive for tracing out delinquent advocates who transgress the norms or standards expected of them in the discharge of their professional duties. The central function of the legal profession is to help promotion of administration of justice. Any misdemeanor or misdeed or misbehavior can become an act of delinquency if it infringes such norms or standards, and it can be regarded as misconduct. Then Black's Law Dictionary, misconduct is quoted: a transgression of some established and definite rule of action, a forbidden act, a dereliction from duty, unlawful behavior, willful in character, improper or wrong behavior. It's synonymous are misdemeanor, misdeeds, misbehavior, delinquency, impropriety, mismanagement, offense, but not negligence or carelessness. The expression professional misconduct was attempted to be defined by Darling J, a solicitor so-and-so, in the following terms. If it is shown that an advocate in the pursuit of his profession has done something with regard to it, which would be reasonably regarded as disgraceful or dishonorable by his professional brethren of good repute and competency, then it is open to say that he is guilty of professional misconduct. In R.D. Saxena, so-and-so, this court has quoted the above definition rendered by Darling J, which was subsequently approved by the Privy Council in George so-and-so, and then observed thus: misconduct envisaged in section 35 of the Advocates Act is not defined. The section uses the expression misconduct, professional or otherwise. The word misconduct is a relative term. It has to be considered with reference to the subject matter and the context wherein such occurs. It literally means wrong conduct or improper conduct.
Advocates Act, it's much wider.
Wide.
Professional or other misconduct may mean anything.
Anything. And this has been incorporated now in the Chartered Accountants Act,
Other.
2006 amendment. The Lordships looks at 2006 amendment or other has been included in the Chartered Accountants Act also. Originally,
Yes.
this wider power was given to the committee while inquiring.
Yes.
During inquiry, they could have looked into that. But now, in the main section of 22, this other thing has been incorporated.
But this complaint was prior to that.
Right. I am not talking about that. Lord, I am saying that what is misconduct is that when you deviate from the standard,
Yes.
if there is a there is a restrictions on audit put by the authority, it has been put with some intention in mind. If you try to violate that, if you
Definitely.
try to take more audit than what is required, then other auditors could also do that.
Right.
I am a statutory, I am one of the complainant is a statutory, acts as a statutory auditor also. I could have done it.
Yes.
But when I find that there is a misconduct committed by one of my brother, and I point it out to the institute, I do it only on the professional platform. I have no personal grievance or personal axe to grind. And that has been found to be correct. And this is what is said, that it's a transgression of established and definite rule of action. This is what it is.
This action can be taken under the Chartered Accountants Act also on information
Yes.
without any complaint.
Yes. Yes.
So if that be so, then it becomes more, I mean, the conduct of the complainant may not be, I mean, the motive of the complainant may not be so germane. You may argue that.
Question. Yes. Kindly, my lord, give me 1 minute. Let me just.
His role is just to bring it to the notice of the court.
It is on receipt of the information.
Yes, yes. On receipt of information or a complaint.
Or a complaint.
So therefore, motive of the, even if the motive was evil, on information, the council can act on that information.
But I would put it this way, that if there is a misconduct, it can't be said that the intention was evil. If a professional brother is conducting a misconduct,
No, suppose Mr. Kaur, in a writ petition or before a court of law or before a court of equity, we may also look into your motive in certain cases. Even if there is a misconduct, we have to see your locus standi
yes,
and your standing as it's called.
Correct,
So
correct.
that standing and locus standi may bring within its connotation your purpose behind, whether it's malafide.
absolutely.
But that cannot be a consideration in this sort of complaints. because this is not an equitable jurisdiction which is being exercised.
Absolutely. I
So
bow down.
it can be also an information.
Yes.
So therefore, maybe it's more diluted in this case
Correct.
than a regular complaint
Absolutely.
before a court or
I bow down.
something like that.
And Lord,
That is what, and otherwise also obviously you have the argument this was prompted by your professionalism rather.
professional.
You are a professional, he's a professional, he's
Absolutely.
guilty of misconduct, he's defaming the entire profession. So that is also one of the grounds you may say.
That is in fact the reason why I had gone before the council, saying that this is something which is can't be done, but he is doing it.
By
and-
chance, one of you is an employee in one of the Birla companies. The other two are his friends.
Lord, the Birla company, the
That's
other two are.
entirely a chance.
But if the complaint doesn't have substance, then it could have
That
been
is what we are
malafide.
saying, yes.
Then it could have been malafide. If the complaint doesn't have substance,
Like defamation. I mean, if
Yes.
it's truth,
then
then
there can't
it
be any
cannot be
defamation.
cannot be.
Can't be any defamation. And Lord, on this, Lord, there is a Delhi High Court judgment. I just want to place it on record. Paragraph, Lord, this is 2010 SCC Online Delhi 4012. Lord, please come to paragraph 14. Your lordships will find.
Yes.
It was, Lord, whether, Lord, a misconduct of a chartered accountant. Paragraph 14, your lordships says, Mr. Agarwal, learned counsel, appearing for the council, argued that the respondent had admitted his visiting business card, which was affixed on the loan application form. Though, as per his own submission, his certificate of practice was cancelled from August 1, 1987 due to non-payment of annual fee, and his membership was also removed with effect from October 1, 1988 till April 30, 2002, and the same was restored on May 1, 2002, when the respondent had deposited the fee for the previous years as well. Although he was not a member of the institute from August 1, 1987 to May 1, 2002, but he continued to be in practice, which is proved by his own visiting card, business card, which was affixed on an application form for loan. Further, the complainant bank has disbursed the professional loan in the category of chartered accountants as mentioned in the receipt, which is annexed at page 66 of the paper book. Furthermore, the respondent has admitted his ration card and signature on the income tax return, etc. Then, Lord, please come to paragraph 28 to 32, 33. Then, Lord, generally, what is misconduct is discussed. Yes. Lord, paragraph 29. The hallmark of a noble profession is adherence by its members to a common code of values and conduct established by its administrative body, including maintaining an outlook which is essentially objective and acceptance of a duty to the society as a whole. Acceptance of its responsibility to public. But these are all not of moral values, etc. Paragraph 31 talks about the code of conduct. Which takes note of a 58 Supreme Court reports judgment of the Supreme Court. Says that if a member of the institute is found prima facie guilty of conduct, which
Your learned junior has found out all the judgments with the keywords chartered accountant and professional misconduct, or only misconduct.
kindly
Please don't multiply.
Lord, this is
We can also do
one.
that at our leisure.
And Lord, the other point is, Lord, with regard to procurement of documents, I say that, Lord, it is settled law that if the documents are genuine, there can't be any questions.
You can cite any judgment on that if you want. If you have brought a judgment, cite it.
Just 70 volume 2 to the page double.
For the sake of conclusion, I mean,
Right.
since you're citing judgment on
Very
misconduct and everything, so why not this also?
70 volume 8. Just I think one paragraph. Paragraph about 18. Paragraph 18, if your lordship.
Yes.
8. Lord, kindly see about 8 lines from the top, paragraph 18, sentence starting with the word, these files are. Last 5 lines from the bottom. These files are said to contain. Paragraph 18.
We shall now proceed to examine.
Yes. Does it start with the word, we shall now proceed to examine the evidence adduced?
That is paragraph 19.
Oh, I'm so sorry.
These files, yes. There is these files.
Paragraph 19.
19, we have these files.
I'm so sorry. Lord,
These files are said to contain.
yes, these files are said to contain the correspondence relating to the election of respondent number 1, exchange between various persons such as respondent number 1, Mr. Birla, so and so. Mr. Sanghi did not give evidence in this case. It is not known how Mr. Chandrasekhar came to possess those documents. Now coming to file A, the story put forward by so and so is that he is a businessman in Bombay. He was a friend of so and so. In his instance, he worked for the respondent number 1 during election. After the election, fearing that there might be a raid on his residence in connection with the evasion of tax, so and so, then the trial court has come to the conclusion that in the file there is not a single document relating to any business transaction. All the documents therein pertain to election of respondent number 1, and there could have been no fear of seizing of those documents. The story put forward by PW14 is on the face of it unbelievable. It is most likely worked for Mr. Murarka during the election as suggested during his prosecution. He seems to be a hard witness, but the fact that a document was procured by improper or even illegal means will not be a bar to its admissibility if it is relevant and its genuineness is proved. Lord, in any event, these documents are public documents. Lord, the balance sheets, the balance sheets can be now obtained under the Right to Information Act also. The partnership deed is the only document which was produced, which is a document which belongs to the partnership firm. But Lord, partnership deed, the genuineness of the partnership deed was not in dispute. And in fact, they have not, Lord, controverted the contents of the document also by producing any other document or to showing that that document lost its force by reason of reconstitution of the partnership at a future date, post that date. That was also not produced.
They filed a written response to the complaint.
Yes.
Show cause or something.
Yes. They did.
Did they mention anything regarding the genuineness of the documents apart from procurement?
No, nothing. The only challenge was to the procurement, how it could be procured. So, Lord, these are my submissions. I say, Lord, there can't be any motive, Lord. This is pure case of professional misconduct, and the complaint is, Lord, based on that. There can't be any motive behind this. These are my.
So you are the complainants. You have heard the institute also. So
Yes.
they'll now be in reply.
Reply, my lord,
When?
maybe on 14th, my lord, 5th is holiday.
Yes, 14th.
No, 12th. I'm sorry. 12th.
12th.
Because Avrojit Mitra and Avrotosh Majumdar both give short reply.
Heard submissions of learned senior counsel appearing for the complainants stroke respondents in the appeal, full stop. On the prayer of learned counsel appearing for the appellant, comma, for the purpose of reply, comma, the matter is reply by the appellant, comma, the matter is adjourned till November 12, 2025.
I'm grateful. Much অনির্বাণ ছিল অনলাইন
এগুলো এর মধ্যে ঢুকে যাবে
এটা চার্জ ছেড়ে দিয়ে
হ্যাঁ এই দুটো জাস্ট একটা ডেটের তো একশো করে দেখো 29 এখানে 29 শুরু করে দিয়েছি না তো এইভাবেই থাক করে থাকলে বোধহয় শুনছে এমনভাবেই থাকছে নাকি দেখে নিও তুমি যে করে একটা রেখে
May.
পাসওয়ার্ডটা আগে
দাদা brief দে দেন madam. Brief.
Password item 2.
Grateful lordship.
I appear for the appellant, my lord.
I appear on behalf of the plaintiff.
It's the trademark matter, my lord. Your lordship had heard me. I'm sorry, my lord. I was not present in the first call.
no difficult.
This will take some time, my lord. Is it your lordship's pleasure to take it? This will take some time, my lord.
Because if you don't take it up, you have to take up the appellate side matters then.
Your lordship
you
could
can-
do that because it will take some time. I do.
Whenever you take up, it will take some time, is it?
I can start that.
Let us start.
Please.
The resolution is no adverse order, so
Resume. That not start. I will resume.
yes.
I'm sorry, my lord. Kindly have, my lord.
Or Mr. Thakkar, if you so want, we can have a first call and see whether anyone else is ready. If you're otherwise inconvenienced or
No, I can do it. But it's just that I will not conclude and it will not. I mean, it will not be very effective. That's all, my lord. Will not be very effective. I can make some progress definitely. I had advanced. I had
because in
made.
any event, we'll be taking written notes. So
Yes,
and you are otherwise also very succinct, Mr. Thakkar.
no, I will be.
So you covered
Matter. Your
some ground and we will
Yes, yes,
start
yes.
from there in the next occasion.
Please, my lord. Please, my lord.
In any event, if every time everyone has to recapitulate, then it will be
Yeah,
very difficult.
Yes, yes, my lord.
It will never be hard out.
Kindly have, please, my lord, my this is stay petition volume 1. I'm on the last. If I may just briefly
Yes.
recapitulate, my
Yes.
lord, I'll take 2 minutes only.
Absolutely.
The respondent number 1 firm, my lord, instituted this suit alleging passing off by the appellant and, my lord, the respondent number 5, saying that now, my lord, the respondent number 2 is the plaintiff who instituted the suit. So 1 and 2 instituted the suit. 3 and 4 were the defendants in the suit, my lord. They are the partners of 1 and 2. The firm, my lord, respondent number 5 was a partnership firm, one of the founding partners of which was respondent number 3. All the partners who formed respondent number 5 were partners of the respondent number 1. In 1984, this firm was formed in 1984. The allegation now is in 2023 that on the demise of the appellant's father, who was the sole surviving common partner in the respondent number 5 and the respondent number 1, the respondent number 5 has no right to continue business under its present name and site. This is what is the cause of action. I'll show you, lordship, which is actually pleaded. If one is to not go by the read the averments in the plaint comprehensively, this would appear to be the actual cause of action. But this is disguised as a passing of action. This is said that the case which is come to court with is that the appellant and the respondent number 5 are passing off the services of the respondent number 5 as that of the respondent number 1 and 2. This is how the suit has been framed as a passing of action. I had shown your lordship some documents on the last occasion. Your lordship will remember how the mark owned by the appellant used for the respondent number 5 was used at the material time, if I may say, because according to me, that is the material time by the respondent number 1.
Even after the breakup,
Even
the
after-
formation of the
yes.
new one, it was being extensively.
It was being extensively used.
The precipitation happened when the father died.
Yes. When the father died, the relations soured, if I may say, between the two firms, and the allegations were made by the respondent number 1 firm of passing off. Kindly bear in mind the dates are very relevant. 1984 was when respondent number 5 was constituted. The partners of who constituted respondent number 5 were the partners of respondent. So if there is any passing off, It is happening since 84 with the blessings of the respondent number 1. Because it's a partnership firm, my lord, it has no independent identity. Unlike respondent number 2, which is recently incorporated as an LLP after the Limited Liability Partnership Act. Now the LLPs have the independent existence, the semi-corporate existence, if I may say. They're not
They're a
exactly.
peculiar genre of creature.
Yes. So, my lord, but the respondent number 1, my lord, partnership firm having no independent existence, its partners go and incorporate another partnership firm, means the firm has directly given its blessings to the incorporation of R5. Now, my lord, on the last occasion, I had shown your lordship some documents. I want to show your lordship what my written notes were, because I had filed a written notes in the matter. If I may come straight to that, and then your lordship will kindly see how the impugned judgment deals with it. Because with the greatest of respect, my lord, the learned judge at the first court has possibly not adverted to most of my arguments, or has not, I find that perhaps with the greatest of respect, the reasoning is not there, or they have not been adverted
Written
to.
notes কোথায়? এটা?
It's in my stay application, my lord.
ও আচ্ছা আচ্ছা।
Volume 1, kindly have.
Oh, the written notes
I
filed
have
before the learned single judge.
Yes, please, my lord.
Right.
Written notes, annex before the learned single judge, page
All right.
17. My lord Justice. Grateful.
Yes.
Page 17, my lord.
Yes.
In the course of, may I just place this, my lord, because this will more or less sum up my argument. It will be more or less a similar argument.
Won't require probably further written notes.
Beg your pardon? No, your
Require
lordship
further written notes.
will be required, my lord, because now I'll have to deal with the impugned judgment.
Oh, yes.
Yes, well, now I have one more hurdle to cross. That time I only had the petition, now I have petition plus judgment. So, my lord, at that stage, petitioners considered that they are not seeking any injunction on the usage of the trademark Fox Mandal and Co. At this stage, in the respondent number 1 is limiting his arguments with respect to his entitlement to use of these marks as to why number. So, now kindly come to page 18.
Yes.
Kindly see A2, please, my lord. The respondent number 1 is the proprietor of Fox Mandal mark, registered as trademark number so-and-so in class 42, and the domain name foxmandal.com. The application for registration of the mark Fox Mandal so-and-so was filed on 7th October 2003, and it was registered on 7th October 2003 and registered on 21st March 2006. Such registration was to the knowledge of the petitioners number 1 and 3 and the respondent numbers 3 and 4, but they never objected to the same. In 2008, this is very relevant, my lord. In 2008, petitioner number 1 applied for and obtained registration of Fox and Mandal as trademark number so-and-so with the consent of respondent number 1 as an associate mark of TM number so-and-so, which was my mark, my lord, of the respondent number 1. Subsequently, petitioner number 1 obtained registration of device mark being application number so-and-so and word mark being application number so-and-so. Both these marks were registered as associate marks of TM number so-and-so. Associate marks, my lord, is under section 24 of the Trademark Act. They are registered when they recognize common ownership.
Yes.
This is under section 24. This is a special category of associate marks. Now, section 24, I'll place, my lord. Now, my lord, 2 marks are registered as associate marks only if they belong to the same proprietor. Refer sections 21C and 16(1)(2). By their act of getting the said marks registered as associate marks of trademark number so-and-so, owned by respondent number 1, the petitioner numbers 1 and 3 and respondent numbers 4 and 5 have unequivocally and categorically admitted the right and interest of R1 in the said marks. The admission was sought to be explained in rebuttal. Registered owner is only prima facie evidence in rebuttal by arguing that the certificates of the said marks record the petitioner number 1 as a registered owner and that the registration is only prima facie evidence of validity of the marks. My lord, I'm not going on their arguments. I'm just limiting to what my case was. How they've dealt with it, your lordship will hear them. And primarily, my lord, my endeavor why I placed this is to show your lordship that most of these submissions were perhaps not adverted to by the learned single judge. That is, my lord, what my case is. Although the petitioner number 1 is recorded as a proprietor of the said marks which are associated with the mark, the respondent number 1, petitioner has never used the same exclusively. This is the case, my lord. Petitioner number 1 has never used the same exclusively, and it is not even alleged that the petitioner has used the said marks exclusively, although the right to exclusive use is the essential right conferred on the proprietor of a registered trademark by Section 28 of the Trademarks Act. Omission of pleading of exclusive user, although continuous and extensive user, there's a distinction here which I try to draw, my lord. There's a distinction between exclusive and a distinction between continuous and extensive. Continuous, extensive go together. But exclusive user is a different category altogether. Is pleaded in paragraph so-and-so of the petition is significant, and no explanation was even proffered. It should be proffered, my lord, for such an omission by petitioners in their rebuttal arguments. This is because the said marks and the goodwill attached to them has been exploited by respondent numbers 1 and 2 to the knowledge of and without any objection by the petitioner number 1. And in fact, petitioner number 1 has been party to such use as more fully stated hereinafter. This is my specific case. I'll tell you a lot about how this has happened. Respondent number 1 firm is, of course, one of the oldest law firms in the country. It is, of course, one of the biggest law firms in Calcutta. But that is where the story ends. Respondent number 1, or the partners of the respondent number 1 at the material time, had the intention to branch out and to make this a pan-India firm. That is why they go to Delhi and set up the respondent number 5. They go to Bangalore and set up another respondent number. This is not party, but one more firm was set up in Bangalore by the name of Fox Mandal Associates, which was headed by my brothers. So I have the senior most partner of the respondent number 1 at the time of his demise was a gentleman by the name of Dinobandhu Mondal, who was the father of the appellant. So the appellant was given charge of the Delhi firm. The appellant's one of the brothers of the appellant was given charge of the Bangalore firm. One brother of the appellant assisted Mr. Dinobandhu Mondal as a partner in respondent number 1. And this is how the business of the respondent number 1 under the brand name Fox Mandal was expanded on an all-India basis. That was for a business purpose to leverage on whatever was the existing Fox and Mandal and to make it into a pan-India brand. And that is why, Mela, the brand which I coined was Fox Mandal, under which all these entities of Delhi, Bangalore, Calcutta, Bombay, Guwahati, and I set up offices thereafter. Respondent number 5, Fox Mandal and Company set up offices in Bombay, Bangladesh, London, all these places. Now, all of these entities used to trade or represent to the world at large that they are part of the Fox Mandal brand, which is the mark, which is your lordship, which is the mark which is set out at page 18. This FN, which I had shown your lordship, was also used there. Yes, used by Calcutta. So this is the business reality. Now, one cannot run away from this today just because this business reality does not change on the demise of Mr. Dinobandhu Mondal. This is how I have created Fox Mandal brand. I am using Fox Mandal brand. You are using Fox Mandal brand. Now you seek to restrain me. This is the long and short of the matter. And these were the arguments, my lord, which were advanced. Now, my lord, kindly see B. The mark Fox and Mandal is a family mark adopted by the Mandal family at least since 1922 after the demise of Mr. J.K. Fox, who was one of the founding partners of the firm. Fox and Mandal, the petitioner number 1 herein, along with Mr. G.C. Mandal, the great-grandfather of the respondent number 1. Then, my lord, is the argument on the Partnership Act. I'm not troubling your lordship with this. Subparagraph III, 1967, the partners of petitioner number 1 have been inducted exclusively from amongst the descendants of Mr. G.C. Mandal. After Mr. Fox left, my lord, none of his branch came in. So after that, it became Mr. G.C. Mandal and his family. This is how the firm was constituted. The said marks are family marks, and the petitioner number 1 is entitled to enjoy the goodwill thereof in the same manner as the petitioner number 3 and the respondent numbers 3 and 4 are doing by virtue of being members of the Mandal family. It is settled law that a trade name of a common lineage is a conjoined property of the heirs and the heirs have legal rights. This dispute must be treated as a family dispute in which all members of the family are entitled to use the said marks which were created and adopted by a common ancestor. In any event, it is a fact that respondent number 1 is the great-grandson of Mr. G.C. Mandal. GC Mandal was one of the two partners who formed the petitioner number 1. The petitioner number 1 was caused to be formed in 1896 by the respondent number 1's great-grandfather GC Mandal, and the respondent number 1, Mal kindly see, cannot be restrained from asserting the foregoing. So my submission was that I cannot be restrained from asserting that my great-grandfather GC Mandal had founded Fox and Mandal, Calcutta. The passing off happens if I say I am Fox and Mandal, Calcutta. Otherwise, there's no passing off.
Yes.
I cannot be restrained from, my lord, with the greatest of respect, claiming my ancestry. I cannot be restrained from saying that my great-grandfather was a great man who founded the oldest Anglo-Indian law firm in the country, or that he founded a law firm in Calcutta in 1896. That is my history. Unfortunately, I'm born in that family, and I cannot be restrained from doing that. This is what the single judge has, the greatest of respect, restrained me from doing.
But in some of your advertisements, probably you have been saying that you are this firm.
I am claiming the legacy of GC Mandal, of the old firm.
You are an old, I mean, the oldest firm.
I'll show you, Lordship.
This is the oldest firm. Something you.
I claim no. So, my lord, those newspaper
You yourself showed those to us.
Yes, I showed that because that.
I mean, in all fairness.
Yes, that is what has weighed on the learned single judge with the greatest respect.
Yes.
The learned single judge has been, my lord, greatly reasoning of the learned single judge comes from those reading
Yes,
of
mostly.
Because the other evidence which was produced by them running into 3 volumes, none of that is even referred to. They don't rely on any of that. Of the other 3 volumes which they rely upon, none of it is referred to in their arguments or in the judgment of the learned single judge. In fact, I have relied on their material to support my defense. In a trademark or passing off, whether injunction or passing off, your lordships would always be confronted by documents showing that I am passing off my goods as his, my bills, my documentation, my literature, and his documents. But none of that. It's just those 3 newspaper reports, publications, advertisements, whatever we call it. But what your lordship is absolutely right. But kindly bear in mind, those same documents, those newspapers clearly talk of a split.
Yes.
The passing off
That's
comes
true.
if there's no split. If I suppress the split and I say I am 1896 Fox.
Even if you say, suppose you pose to be the oldest firm.
Correct.
That posturing does not amount to passing off. You have to say, I am Fox and
Mandal, Calcutta. And all of those 3 publications unequivocally say that Fox and Mandal, Calcutta remains with the gentleman named as respondent number 4. And I am Fox Mandal, Delhi. And I have inherited legacy of Fox Mandal. My inheriting legacy is a claim which I say is my grandfather.
You have a right to puff your chest and all. I mean, these things.
This is a puff.
But this is a puff, basically. But that does not tantamount to passing off.
Have I said, if I had said that I am Fox and Mandal, Calcutta, and Fox and Mandal, Calcutta has opened a branch in Delhi, and both are one and the same, then and only then can it be passing off. And also bearing in mind the class of, it's not the class of prospective clients. The class of prospective clients who would have a chance, or to whom this puff or this publication, let us say this is an advertisement which I have caused to be published. Even if I take it to that extent, would the litigant who would be availing of either of our services would be misled into believing that the firm run by the appellant in Delhi is the same firm as run by the respondent number 4 in Calcutta? Because after all, this is a firm of lawyers. The name matters, but clients do not deal with firms, they deal with persons. The lawyer who's handling the client's case, the lawyer who's advising the client. None of this has been considered by the learned single judge at that stage. Although, my lord, he went entirely on the basis of the advertisement. Now, my lord, kindly see, I'm omitting C for the time being, because this is on a contentious issue, share of late Dinbandhu Mandal, because this has been held against me in another suit. So the partnership deed, I'll tell you, lordship, briefly what this is. The partnership deed of the respondent number 1 provides that on the demise of any partner, the goodwill will be valued by Mr. Dinubandhu Mandal. And money will be paid in lieu of goodwill. But the goodwill will remain that of the firm. So I said that this is person specific, that is Mr. Dinubandhu Mandal specific. Now, what is Dinubandhu Mandal's share in goodwill Dinubandhu Mandal is not there to ascertain.
Hmm.
But a suit was filed by the respondent number 1 seeking a declaration that on my father's demise, I'm only entitled to rupees so much in terms of clause 17 of the partnership deed and whole lot of injunctions. The suit was decreed. The injunctions were denied. The injunctions were held to be barred by law, but the decree was made for the sum money amount. So I'm not troubling your lordship with C now because I have other things to come to. Kindly come to D. And this is what I was asserting.
Yes, that FM.
Goodwill of the said marks is a shared or common goodwill in which the respondent number 1 has also contributed and is entitled to enjoy the benefit of.
Hmm.
The petitioner numbers 1 and 3 and the respondent numbers 3 and 4 have exploited the goodwill of the respondent number 1's Fox Mandal mark, registered at so-and-so to advance the business of the petitioner number 1. This is a case of reverse, my lord.
Hmm.
This is established from the following, all these documents, my lord, some of them I have shown you, lordship.
Yes, sir. Yes.
Kindly come to. Now, my lord, the domain name foxmandal.com is owned by the respondent number 1. This domain name was used by the petitioner number 1 and its partners. As will be evident from these are all, my lord, documents disclosed by the petitioner. The screenshot of the website is of foxmandal.com and the parties used a common website and domain name foxmandal.com, which is owned by the respondent number 1. The brochure attached at pages 558 to 573, all of the petition dates back to approximately 2006. This is the document which they annex, the brochures, to show that I was passing off, but this brochure is of circa 2006, which includes my office in Delhi, my brother's office in Bangalore, my office in Bombay, my offices in London and Bangladesh, and the office in Calcutta as part of one entity, Fox.
Letterheads also probably.
Letterheads also. The, my lord, I'm not very sure what it's called, my lord, the address, at the end, bottom of the page.
If you don't know, I don't know.
No, I don't. It's not subscript, but I don't know what it's called exactly. But they have all the offices there.
Footnote.
Footnote, yes.
Roughly, yes.
So, the footnote would show all the offices.
Yes,
Footnotes
we
of the
remember that.
letterheads used by them.
You showed those on the last
Yes.
occasion.
So this is what I said, my lord, common goodwill. I have contributed, or my mark has contributed to their growth. The respondent number 4, who's a partner of the petitioner number 1, has sought to rely upon the business connections. Kindly see. The respondent number 4, who's a partner of the petitioner number 1, has sought to rely upon the business connections and goodwill of the respondent number 1 and the respondent number 2 to advance the business of the petitioner number 1. Copy of the email dated so-and-so sent by Devanjan Mandal, respondent number 4 to R1, which was relied upon at the time of hearing, is enclosed with this note and marked with the letter A. This was produced, not along with the affidavit, but at the time of hearing, and a copy was also given here. The respondent number 2 firm was constituted by petitioner number 3, respondent number 2, and late Dinbandhu Mandal in 1984, when all of them were partners of the petitioner number 1. Late Dinabandhu Mandal was partner of the respondent number 2 till his demise. It is repeatedly alleged in the petition, paragraph so-and-so, that the petitioner number 1, now this is the pleaded case. It is that the petitioner number 1 permitted late Dinabandhu Mandal to carry on the business of the respondent number 2 and use the marks Fox Mandal and Company, Fox Mandal and the logo FM. This is the allegation, not a shred of documentary evidence. However, late Dinabandhu Mandal was not the sole proprietor of the respondent number 2. And respondent number 1 was partner of respondent number 2 since 1996 along with others. Further, Fox Mandal and Company, Fox Mandal and the logo FM are all owned by the respondent number 1 and not by late Dinabandhu Mandal since inception. In fact, these firms, both these firms, neither Delhi nor Calcutta ever got their marks registered. It is only when I came in subsequently after the constitution of the respondent number 5, the Delhi firm, if I may say, that I developed the mark Fox Mandal, because before that nobody used Fox Mandal. They cannot show a single piece of evidence that Fox Mandal FM, as we see on their letterheads, was ever used by them before me. I coined these marks, I designed these marks, I registered these marks. Then, And these marks were owned by me, nothing to do with Dinbandhu Mandal or the other partners of respondent number 1. Save and accept the bold and repetitive allegations. The permission allegedly granted to late Dinbandhu Mandal by petitioner number 1 have neither been pleaded nor is any evidence adduced. The case pleaded in so-and-so of the petition have no right to use the marks. Now, the case pleaded is this, my lord, and I'll show your lordship. The case pleaded in paragraphs 22 and 58 of the petition that respondents have no right to use the marks owned by respondent number 1 after the death of Dinabandhu Mandal, as there is no common partner between the petitioner number 1 and the respondent number 2, itself destroys the petitioner's alleged cause of action of passing out. These are two, my lord. Now we stand on one is a revocation of license. One is revocation of license and one is passing off. These two actions are entirely different. The test is different. The cause of action is different. This is his pleaded case that after Mr. Dinubandhu Mandal passed away, you have no right to use the mark. So now one has to test at the interlocutory stage whether there was a license granted at the first place and whether the license was or could have been revoked. If it was revoked, the legality of such alleged revocation. This, my lord, with the greatest of respect, the learned judge has not considered. He has treated it purely as a passing of action.
Still continue from here, sir.
Well, just for my understanding, that other matter is also kept on 12th. My matter will be after that matter or before this matter, just so that I can. Mr. Kaur's matter.
সেই অর্ডারই তো থাকবে। আজকে যে অর্ডারে থাকে সেই অর্ডারই তো পরের দিন থাকবে।
Whatever your lordship desires, whichever matter your lordship finishes.
আছে সেই অর্ডারই তো থাকবে।
Grateful.
Heard in part for further hearing on November 12, 2025. 12.
Grateful.
Yes, this is order 41.
May I have your lordship's kind leave, my lord. With the leave of Justice Uday Kumar, may I mention a matter pertaining to your lordship's single bench, my lord. It was some revisional applications.
Hand
My
over.
lord, may
My
it be
lord,
listed on
kind-
Friday, my lord, some preference because the matter is fixed on the lower court on Monday.
Preference, huh? These have been assigned to us.
My lord, a bunch of matters which was sent
No,
for-
that was before the vacation. Those automatically were to go back to the previous bench. Those who are assigned, the assignment was very specific up to that pre-vacation date. That is not a general assignment. Yes.
My lord, may I pray for a, my lord, mentioning, my lord, this is an application for inclusion, my lord.
Come back next week. Yes.
Okay.
My lord,
Grateful, my
You
it's
first.
kind leave to mention a matter. My lord, I'm mentioning upon notice, my lord, this is a part heard matter. My lord, excuse me for mentioning that. One of the difficulties we also will recollect, this pertains to the interplay of section 11 and section 15 of the Land Acquisition Act. It was argued in length by Mr. Arindam Banerjee and Mr. Corvus, who is my
But this is
leader.
not appearing in the list.
It is appearing in the list. My lord, I bring some upgradation. Item number 72 of my lord's DSP.
Not possible. No.
My lord,
Come,
may I,
please. My lord, my entire project is stalled because of
No, no.
one sanction from WB.
Not possible. No.
Your Lordship, this is an appeal against the order of single bench. We have already
Mention next week, ma'am. Yes.
Your Lordship, the
Next.
eviction notice was on 4th November.
Mention next week. Yes.
lord, may I permit to mention order 41 rule 11.
Come back next week. Order after one we have taken today. We will take all the other matters next week. Come back.
Lord, may
Next.
I mention,
Yes. Next.
Item
call-
number 1.
This is my application, my lord.
In the event, কমাটা হবে। Yes, Ms. Bose. The matter was now we had dismissed the matter for non-prosecution yesterday, that is on October 28, 2025, since repeated adjournments were being sought. Full stop. After the matter was dismissed yesterday, comma, before rising of court, comma, Ms. Bose, comma, appearing for the appellant, mentioned the matter and submitted that she was in difficulty due to medical ailments, as well as that the matter arises from the legal aid. Full stop. Keeping in view such considerations, comma, we are of the opinion that the litigant, comma, who is already on legal aid should not suffer the ignominy of being compelled to file a further restoration application. Full stop. Accordingly, on the verbal prayer of Ms. Bose, comma, we recall the order dated October 28, 2025 and restored the appeal and the application, that is FA 194 of 2019 and CAN 2 of 2025 to their original file number. Full stop. The matter shall be listed under the original heading on November 3, 2025.
My lord, one indulgence, my lord. When I serve the copy, the last order,
We have just restored on your oral mentioning. Whenever it comes up, we'll take it up. But this time, please ensure that somebody who is prepared in the matter comes.
my lord, I apologize again.
No,
my
no,
lord,
no,
for-
no, no difficulty. Yes, call on.
Item number 2.
ये फाइल টা ready করো। You're appearing.
Your four respondents.
Shomik Ganguly was appearing. They have served you copies of.
Yes.
None appears for the appellants at the time of call, although the respondents are represented through counsel. Full stop. Let the matter stand adjourned for the day.
Or may it be on Monday so that we can also get
Adjourned for
the.
the day means Monday, because Friday we take up we sit singly.
I'm grateful to you.
Thank you.
Item number 3 with 4.
Lordship, I'm appearing for the appellants. I'm praying for an adjournment for today. Mr. Mitra was addressing your lordships yesterday.
Yes, yes.
Commercial court matter, my lord, whether the matter is a commercial.
Why it's a part? I already heard him.
Your lordship, Mr. Mitra is in some difficulty today.
He was to cite some judgments only.
Yes, your lordship.
What are those judgments? Cite those judgments. You take those.
I'm kindly requesting for Monday.
I'll only request one thing, let the citations at least
We'll
be
give them a copy of the
Very well. In the
judgment.
prayer of the appellants, the matter is adjourned for the day. The matters are Kurudu. Please give your names. Don't give the name of Mr. Mitro. Yes. Yes, Mr. Chatterjee also given.
Item number 5.
5.
Item 5, my lord. I'm in a similar quandary, my lord. My leader, my lord, is not here right now. Perhaps
Mr. Mitro.
No, my leader was Mr. Siddhartha Banerjee, my lord. My lord will recall Mr. Siddhartha Banerjee was reading me. Mr. Joydeep Kaur was the respondent. I don't find Mr. Kaur either. My lord will kindly make it not today, my lord. We'll take our chance next day.
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day. ওনার নামটা লিখে দিন সৌনকের নাম প্লিজ গিভ ইউর নেম and whoever is present today.
Item number 6.
My lord, I'm for the petitioner, my lord.
Yes.
So the service now has been done, my lord. Kindly appreciate to that.
Learned counsel for the petitioner seeks an adjournment on the ground that service on the respondent has not yet been completed. So let the matter stand adjourned till
2 weeks, my lord. 2 weeks, my lord. Yes, sir.
adjourned till November 17, 2025 on the prayer of the petitioner.
Much appreciated.
Item number 7.
7, my lord.
Yes.
Affidavit in service.
Yes.
It is.
There are private respondents also.
There is no private respondent.
Good. What is the matter, please?
The order of ex parte order.
A land reform sector din. No, estate acquisition. This will be, we have to have with us the Estate Acquisition Act or the Land Reform?
No,
Act?
land reform.
Land reforms. Land reform side. Yes.
54 recourse not taken. That's why I'm not entertaining this. This is the crux of tribunal's order. Why didn't you go
Well,
under section 60?
We are the recorded owner.
Yes.
We are not given any notice and proceeding was concluded behind our back. That was the subject matter of challenge. And matter section 5 application was filed by us. In 2015, my lord, OA application was entertained by directing the file opposition in respect of the section 5 application.
So why didn't you take recourse of section 54? File an appeal, rightly rejected. Go and file an appeal.
My lord,
You cannot bypass the route, the statutory route.
my lord, they have relied upon the judgment, which is not, my lord, relevant.
No judgment is required. Appeal is there.
My lord,
Appeal
the
provision is there.
hardship is there. My lord, I have
Whatever hardship, go to the appellate court and
my lord,
canvass your hardship.
kindly take up the, my lord, section 10.
What is the hardship? The appellate tribunal is
My
not
lord,
functioning. Forum is
we
not
are the-
functioning.
Act remains that we are the recorded owners. We have paying rent.
It is on the merits, but you have an appeal before you.
My
Go
lord,
to
no
the appellate court.
opportunity, my lord. Now, my lord, the entire thing is that, my lord, without giving any opportunity, any notice, my lord, section 54 says, kindly take up the section 54
Yes.
for a moment.
Yes.
51A4. Kindly take up section 51A.
Yes.
Then, my lord, kindly take up section 4. Any officer specially empowered by the state government may, on an application within 1 year or his own motion within 35 years from the date of the application or record of rights, subsection 2, revise any entry or finally publish according to the provisions of subsequent 2 after the person interested is giving opportunity of hearing. So we are not given any opportunity in nothing. I shall satisfy your lordship, my
Why
lord.
do you go before the tribunal directly? What can the tribunal do? It will usurp a forum.
But
Both of you are losing a forum if you don't challenge under section 54.
kindly take up impugned order for a moment.
Whatever is the impugned order, the impugned order of the tribunal.
No, passed by the.
No, we won't look into that. Go to take the.
Kindly take up the.
No. Take recourse to the appellate
My
court.
lord, kindly take up the tribunal order.
Yes, we are looking. We have seen that already. Not purely a question of law, rather mixed question of fact and law. Jurisdiction tribunal cannot be straight away invoked. Rightly so.
But the issue of hardship in the third paragraph, issue of the hardship as ordinarily taken on the part of the plaintiff, we have raised that point.
What is the hardship?
Hardship means that my land will be taken up.
For that you can go to the tribunal, but you cannot go to the appellate authority.
My land without giving I was the recorded owner. My record of rights is my name.
Again and again we are telling you, you are addressing the merits of the matter, which the tribunal rightly did not go into because you have an appellate recourse. Take recourse to an appeal. If you fail there, then come to the tribunal, then come to us. No.
My lord, I am relying upon the judgment, my lord.
But if you find that this is a frivolous application, we will impose costs on you. Please cite your judgments. Because we find prima facie this is absolutely frivolous. You could find the time to go to the tribunal to challenge in 226, and you could not find the time to go to the appellate authority, and you are claiming hardship. We'll impose exemplary cost on your client if we find that it's frivolous.
My lord, as because, my lord,
226, who says it's not maintainable? But alternative remedy, exhaustion of remedies has to be there. That is what has been held here.
my lord, paragraph 7.
Yes.
Paragraph 7. My lord, 3 grounds are taken where the writ petitioner seeks enforcement of the fundamental right.
Please read it out. It's paragraph 7.
So far as the view taken by the High Court that the remedy by way of recourse of arbitration of clause and availability of the appellants, and therefore writ petition filed by the appellants was liable to be dismissed in concern. It is observed that the rule of exertion of the writ petition by way of availability of remedy is ruled for the discretion as in the case of compulsion. In any appropriate case, in spite of the availability of the alternative remedy, the High Court may still exercise its writ jurisdiction at least 3 consequences. First is where the writ petition seeks enforcement of any fundamental right, where there is a failure of the principle.
We have finished reading it. If you have finished, we'll pass our order.
But a failure
Ash.
principle of
The present challenge has been preferred against an order of the tribunal whereby the West Bengal Land Reforms and Tenancy Tribunal, first bench, turned down a challenge to an order passed by the BL and LRO on the ground that an alternative remedy of appeal was available. Whose of next para, learned counsel for the petitioner pleads hardship and cites such and such, Harbanslal namta diye debe, reported at 2003, volume 2, Supreme Court cases 107, for the proposition that availability of an alternative remedy is not absolute bar to the writ court entertaining an application under Article 226 of the Constitution. Full stop, next para. Upon hearing learned counsel for the parties, we find the arguments of the petitioner untenable in law. Full stop. It has what has been laid down in the by the Honorable Supreme Court in the cited judgment is that the remedy by way of recourse to arbitration clause cannot be an absolute bar to the writ court entertaining an application under Article 226 of the Constitution, because it was held by the Supreme Court that suffice it to observe that the rule of exclusion of writ jurisdiction by availability of an alternative remedy is a rule of discretion and not one of compulsion. Full stop. Even the Honorable Supreme Court laid down certain exceptions when the High Court may still exercise its writ jurisdiction, where the writ petition seeks enforcement of any fundamental right, where there is a failure of principles of natural justice, or where the orders or proceedings are wholly without jurisdiction, or the virus of an act is challenged. For some next para, we do not find any of the said circumstances in the present case, since the learned tribunal acted absolutely within its jurisdiction in observing that the tribunal is not inclined to interfere in the matter, since a provision for appeal is available under the West Bengal Land and Land Reforms Act against the order of the BL and LRO. Full stop, next para. In fact, it is well settled that the High Court or the tribunals invoke self-imposed restriction where an alternative remedy is available, to ensure that the statutory hierarchy of appeals is adhered to under normal circumstances, and the jurisdiction of appellate forums in the intermediate tiers, TIERS, are not bypassed. full stop. Hence, comma, we do not find any illegality or jurisdictional error in the impugned order of the tribunal, full stop. Accordingly, WPLRT 174 of 2025 is dismissed, thereby affirming the order dated July 2, 2025, passed by the West Bengal Land Reforms and Tenancy Tribunal, comma, first bench in MA 14 of 2015 within bracket OA 58 of 2015 bracket closed of LRTT. Full stop. Next para, it is made clear that it will be open to the petitioner to challenge the originally impugned order of the BL and LRO before the appropriate appellate authority in accordance with law. No orders to cost. প্রথমেই affidavit is filed to be kept on.
One thing, my lord, kindly direct the BLO to supply the copy. My lord, I have demanded.
You won't direct anything, you approach the BLO. But does the presumption arise that he will not give the copy? Yes, Colonel.
Item number 8.
8.
My lord, the service has not been done. My lord, kindly appreciate.
Why none of your matter service is done?
My lord, during vacation, my lord, could not be served.
You are over and out during the vacation.
No, just before vacation filing.
Learned counsel for the petitioner seeks an adjournment on the ground that service has not yet been effected. Accordingly, let the matter stand adjourned till November 17, 2025.
Much obliged. Right now.
Item number 9.
Yes, Mr. Chatterjee, what is the matter?
But I am for the appellant wife. That is the perjury matter. Mr. Basu was appearing.
You are alternatively appearing before this man. Either you or Mr. Bose. Well, Mr. Bose took information that you are coming. That's why. Anyway, none appears for the respondent. Let the matter stand adjourned for the day. But both of your quotas are over. On the next occasion, whoever does not appear will hear the other say.
Last day he rebuked me very much. You told me that you won't appear. Why you appeared online?
But tell him, Mr. Chatterjee, that we have said this. That whoever does not appear loses. Sharanya Chatterjee, your name. Next.
Item number 10.
Can your lordship, Mr. Probal Mukherjee is appearing. Your
So what? You move the matter.
I
No
pray
further
for
adjournment, no.
No, lordship, I pray for not today. Your lordship, I don't.
Where is the brief?
Lordship,
On the prayer of the appellant, the matter is adjourned for the day. আমরা চাই জুনিয়ররা মামলা করুক, যদি তারা না করতে
Number 11.
আমি আর কাউকে করতে বলবো না, যে করবে করবে। None appears for the parties, adjourned for the day. আর চান্স দেবো না, জুনিয়রদের মরুক কিছু, যে করবে করবে, যে করবে।
Item number 12.
ডেকে ডেকে নেমন্তন্ন করে করাতে পারবো।
My lord, I am for the petitioner.
Yes, Mr. Gupta, what is the matter?
My lord, this the appeal has arised out of a preliminary degree passed in a partition suit, my lord.
Just let us have the brief first. তাড়াতাড়ি। Partition suit preliminary degree?
Preliminary degree has been passed, my lord.
You have challenged that?
I have challenged that, and also, my lord, what has happened, my lord, I filed an application for addition of party because my case is that one Bina Das, who was my grandmother, she has executed deed of gift in my favor. That is why I filed an application for addition of party. That addition of party was allowed. But in the final, in the preliminary degree, my deed of gift was rejected or was cancelled. That day I could not prove the deed of gift. Therefore, my lord,
that was also one of the prayers in the partition suit.
Yes, my lord.
Cancellation of deed of gift was also one of the prayers in the partition suit.
No, my lord. I added as party, my lord. But cancellation, deed was gift was executed in my favor, my lord.
How can it be cancelled by the court in a partition suit? Was there any prayer for cancellation?
My lord, only partition, my lord. Only simple partition.
You are saying the trial court cancelled your gift deed?
Yes, yes.
Without any prayer for cancellation? How can the court cancel you?
My lord, I have not prayed. My lord, I prayed for my share, my lord. I prayed for my share.
Nothing was proved in the trial court, my lord.
The gift deed was cancelled.
Yes, my lord.
My lord, that is not proved because, my lord, donor.
My lord, if your lordship can come to the order dated 14th of May 2024, passed by the division bench of my lord Justice stand on, my lord.
Yes, deed was held to be invalid. There was no prayer sought for cancellation of the gift deed. Let us see the plaint, Mr. Gupta. Have you annexed the plaint? You must have annexed the plaint in the injunction application.
My lord, three brother.
Oh, we were not interested in brothers and sisters. Show us the plaint.
My lord, may I submit, my lord, only one thing, my lord. That is the subject matter of challenge, my lord. In
Let
this
us see the plaint. How do you know the subject
Plaint
matter of challenge?
plaint
You
এখানে
don't
নেই
have a
বলে।
copy of the plaint. How do you draft
My-
the appeal? We don't understand.
plaint আছে, my lord.
You have not prepared yourself, Mr. Not at all. Not at all.
My lord, I have
Let us see, we have got a copy of the plaint.
my lord.
Yes, yes. You are saying no, but it is wrong. That prayer was incorporated. Alleged deed of gift dated such and such is declared to be void and inoperative. That prayer was made in the plaint. It was amended.
But that is the subject matter of challenge, my lord. Please
So what
give it-
prayer? What sort of
my lord,
usual order? The
my lord,
everything
my
will
legal
continue
order
to
was
final
passed
decree?
by my lord justice stand on, my lord. Division
Achha.
bench of my lord justice stand on, my lord. That
In
is
this
the-
appeal?
in this appeal, my lord.
Which date?
That
What is the date?
order dated, my lord, 14th of May,
Yes,
2024.
yes. What was that? Can one was the
My lord, page 61
time
of
and again
can
this
2.
photo is-
Can
61 of this application, which is before your lordship now.
Yes, the usual order has been passed.
Usual order has been passed, my lord. What has happened, my lord? My lord,
Now what are you wanting?
my lord, my lord, my lord, subsequently, my lord, it appears, my lord, that a probate was that a will was executed by one of the co-sharers, my lord, by one of the co-sharers in my favor, my lord.
Will.
Yes, my lord. Will. I have filed an application for probate before the testamentary and original jurisdiction of this honorable court. My lord Justice Division Bench of my lord Justice Somen Sen called for a report that what is the stage of the probate proceeding. My lord, that was the last order passed by the Division Bench of this court, my lord. That whether we are continuing with the probate proceeding or not. My lord, if the probate proceeding is pending, my lord, there must be stay of all further proceedings of the appeal, my lord.
But you have not disclosed the probate proceedings. The will.
Yes, yes.
In the
This application,
Yes,
my lord, that was discovered subsequently, my lord.
you have to amend the plaint before this court. You have to seek an amendment of the plaint, bring the
My lord,
pleading on
plaint I am
record,
not a-
produce, take out an order for 27. Are you to advise you, Mr.
My
Bidutto?
lord, my lord.
Unless those are there in the
My lord, I
pleadings,
am not the-
this is alien to the suit. On what ground should he alter the order of Justice Tandon?
on page 48, he's claimed the share of Sopon. On page 48,
Upon has executed
will.
So why shouldn't it be stayed?
He's paying 48. It is already declared after Sopon Das died on 14 January 2022 during the
Page
pendency
18,
of the
my lord, of
suit.
this application.
Thus, these two brothers and sister inherited 1/4 share of jointly of the Sopon. That is declared.
No, who inherit jointly? You and you, him and you.
My clients and
yes, if there is a
father-
will by
and
Sopon,
father of the appellant.
if there is a will by Sopon in his favor, only he gets it.
My lord, he
But
gets
Unless
it,
that is decided,
Probate proceeding, my lord,
unless
this
that is
application.
decided, how can the partitions should be
my lord,
decided?
my lord, during pendency of the suit, my lord, he added he paid application for addition of party. My lord, he is the son of my lord, one
My lord, one of the co-sharers,
defendant, one co-sharer.
He claimed on the basis of a gift deed.
Yes,
that
my
gift deed was declared to be void.
Actually,
Therefore, listen.
my lord.
First, listen. We cannot all speak together. So let us listen to each other. He sought to implead himself on the ground that he has a gift deed by
Yes.
one of the co-sharers. Gift deed was held to be a nullity or whatever, declared void. Therefore, he was not added. Or was he added?
He
Yes,
had
my lord, he was added, my lord.
He was added.
His father
But gift
not-
deed was held to be
Yes, my
bad.
lord, invalid.
Bad.
Now he is claiming on the basis of a will of one of the
Now,
co-sharers, not the
thereafter he
gift deed.
preferred appeal. During
Obviously, thereafter he preferred an appeal.
prefer appeal.
How can he prefer an
During-
appeal before the decree?
My lord, during pendency of the appeal,
Don't repeat what we know already.
my lord,
Obviously, during pendency of the appeal, he has discovered a will, has taken out a probate proceeding.
yes, my lord.
Why
But
should
it-
the suit not be
but
stayed?
will is executed in the year 2022.
My lord,
Well, now it is
my lord,
But
appeal,
now there is a probate
2012, my lord. Will is executed in 2012.
My lord, page 18 of this application, my lord, at paragraph 10, my lord, I have categorically stated, my lord. Page 18, paragraph 10 of this application, my lord.
But if your lordship kindly,
10 onwards.
kindly allow the short list of date, my lord. Short list of date.
Thereafter, my lord, a report has been called for by the division bench of this court, Justice Somensen, and report has been submitted by the testamentary department. I think so, my lord, that has been submitted, but we have not obtained.
What is the stage of the partition suit? Partition commission has been held.
My partition
that-
commission completed.
Completed, huh?
That is completed.
That was the direction of this court.
In
That
any
is
event-
continuing, my lord. That is continuing.
That is completed, my lord. I
Says
mean,
that is completed. Take instruction.
That is not my instruction.
Whatever there is already a decree, an order restraining the trial court from passing a final decree.
Yes, my lord.
So commission work either continuing or completed.
Yes,
so
my lord.
let him. No final decree will be drawn up. Why further stay?
The stay of the appeal, my lord, because when the appeal of this court is pending, my lord.
This appeal?
Yes, my lord, this appeal.
totally res judicata.
My lord, your lordship kindly see the order passed by Justice Somen Sen, my lord. Division Bench of Justice Somen Sen.
Asked for report, only report.
29/7/2025, my lord. That whether we are proceeding with the probate proceeding or not, but that was the report called for by their lordships from the department.
What is the stage of that? I mean, you don't find any report here.
Citation issued.
Report
The
after
citation is served.
I think that they had appeared already probate proceeding in the.
My client is not appeared, ma'am.
Appear করেনি? Appear করেনি?
এখনো ক্যাভিয়েট ফাইল হয়নি কিন্তু সাইটেশন ইস্যু হচ্ছে
We filed the probate proceeding only on 24th of September
But
2020.
after obtaining, my lord, your lordship kindly see.
Reports of
We
the
have,
state.
we have obtained.
But you should also file an application for amendment of your pleading here in the suit.
My lord, shoot I have not filed, my lord. Shoot is not mine, my lord. Shoot
You have not filed any written statement.
Written statement I filed, my lord.
So you need not amend the written statement to bring on record this pleading that there is a will. You are claiming your right through the will. This is a different right. You are not required to file an amendment application. Or to file an order for Rule 27 application.
I came to know, my lord, during the pendency of the appeal before this honorable court, my lord.
In the year 2012, it is.
Mr. Gupta, you are practicing since before I started practice.
My lord, that I know, my lord.
Aren't you understanding what we are telling you?
Yes, my lord. In the appeal,
Are you to believe this? What submission you are making? I am compelled to say this. During pendency of the appeal, there cannot be any amendment of the pleadings.
Yes,
if subsequent facts come on record. And you are relying entirely on that to claim your right. What submission you are making? We are, instead of us advising you, you should have advised your client and you should have filed that amendment application in the order for Rule 27 application. Otherwise, we cannot look into any probate proceeding. As far as this court is concerned, the pleadings, we are an appellate court from a particular decree passed in a suit. If there is nothing in the pleadings of the suit, you have to amend the pleadings even in appellate stage, you can do that. And you have to do that. Otherwise, there is nothing on the pleadings to mention about any will. How should we look into a will? How can we look into any will or any probate? Nothing is on record in your pleadings. Till date, there is no pleading saying about any will. Let alone in order for Rule 27 application being filed to seeking leave to bring that on record. So as far as we are concerned, we are looking at the plaint, whatever pleadings there are. There is no mention of any application, any will. So there is no scope of any grant of stay. Why should we?
Well, otherwise, my lord, if your lordship can consider, my lord, if the appeal is disposed of, although my lord
very well, paper books have been prepared and the records have come. Let those proceedings continue. We'll consider at the time of.
Actually, my lord, paper book, Rule 20, Rule 12 notice.
Which is the can 2? Can 2 is the stay application.
Before your lordship, my lord, can 2 to
can 2 is the stay.
Can 2 is my lord before.
And can 3 you have prayed for
paper book.
Paper book is not. You have made that application.
Yes, ma'am.
Paper book application. We'll allow can 3. We'll direct them to prepare paper books, and you are the only. All the respondents are present.
Yes, ma'am.
Well, service of notice of the respondent has been dispensed.
So he is appearing for dispense with. It's complete as regards service. Let them prepare the paper books. The stay application will be taken up along with the hearing of the appeal when it is taken up. Can 3 of 2025 is an application for appropriate orders for preparation of paper books on the respondents. Full stop. The same is allowed, thereby directing the respondents to prepare and file the requisite number of paper books within 8 weeks from. You have already got notice of the.
Paper book, I informed that no record is arrived.
My lord, there was a directive
Whether he-
passed by the
Within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondents. Push up next para. Can 2 of 2024 is an application seeking stay of all further proceedings of the present appeal on the ground that during pendency of the appeal, comma, the appellant has learned about a will left by one of the deceased co-sharers. Full stop. It is submitted by learned counsel for the appellant that after coming to know of the said will, comma, a probate application has been taken out, which is now pending in the testamentary division of this court. Full stop. Next para. Learned counsel submits that unless all further proceedings of the appeal are stayed till disposal of the probate proceeding, comma, the hearing of the appeal will be an exercise in futility, comma, since the outcome of the probate proceeding will directly affect the result of the present appeal, as the shares of the parties would change in the event probate is granted. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that there is no impediment in the paper books being prepared in the meantime and the trial court records arriving before this court. Full stop. Hence, comma, let the records be examined by the office and, comma, if found to be complete in all respects, comma, the appeal be made ready for hearing otherwise. Full stop. Next para. The stay application shall be taken up along with the appeal. The stay application, that is Can 2 of 2024, shall be taken up along with the hearing of the appeal in order to ascertain the then current status of the testamentary proceeding. This application will appear along with the appeal whenever it appears, Mr. Gupta. When it appears, even if then the testamentary proceeding is still on, then we'll consider the stage of the testamentary proceeding and decide.
Kindly direct the appellant to supply a memo of the appeal.
No. The notice of paperwork will be given to you. Prepare a formal paperwork. We won't expedite that so that he has some time to carry on with the testamentary proceeding. We are deliberately doing that. You will file formal paper books, let the records come, no special messenger, nothing. So let the appeal get ready. In the meantime, let him proceed with the testamentary procedure. And we'll take up this stay application when the appeal is matured for hearing. If even then it is pending and it is at a ripe stage, then we may not take up the appeal for hearing unless that is done. That's why I have kept it pending. Yes, Mr. Next. Yes.
May it please your lordship, my lord. My lord, I'm appearing on behalf of the appellant. My lord, on the last occasion, your lordship has told me to move the matter today before your lordship.
Thank you very much. Mr. Nondi. You are Mr. Nondi?
Yes.
Yes. What is your matter?
My lord, this is a very unfortunate matter, my lord. And why I am saying so, because, my lord, I am against a suit, my lord, under Hindu Adoption and Maintenance Act, where the learned judge was pleased to pass an order of maintenance amounting to the tune of rupees 15,000 per month. My lord, till date, my lord, I am paying the maintenance, my lord. My lord, I have 2 applications before your lordship, my lord.
What was the suit for?
My lord, suit for Hindu Adoption and Maintenance Act.
Suit was for maintenance?
Yes, my lord.
The marriage is subsisting between you?
Yes, my lord.
There is a child of the marriage?
Yes, my lord.
How old?
My lord, she is major, my lord, and a service holder.
She is major but unmarried?
Unmarried.
So she is also entitled to maintenance?
No.
What was granted? Maintenance was granted only to the wife?
No, my lord, both to the wife and the daughter.
15,000, what do you do?
My lord, I am a retired person. I was a government employee. My pension is rupees 26,000 and not more than 27,000, my lord. My lord, till date, I am paying, my lord, rupees 15,000 per month.
Section 5 is there?
Yes, my lord. My lord, my Can 1 application is for Section 5.
What is the delay?
My lord, delay is, my lord, 575 days. My lord, kindly comes to paragraph number 10 of my Can 1 application.
Yes,
10.
10.
My lord, may I read it, my lord?
Yes, please.
My lord, your applicant defendant states that thereafter...
Wrong advice. Who was the present advocate? Which advocate? Advocate in this court?
No, my lord. In the court below, my lord. Learned court below.
No, you have to give a notice to the advocate. Whenever you cast a blame on the advocate, we have to just one line stating one line wrong advice from previous advocate does not. Miscase was filed.
Yes, my lord. Wrongly one miscase was filed, which I have already withdrawn, my lord.
When was it filed? In which court? Before the trial court?
Yes, my lord.
Miscase under which provision of law?
Last year, 8 ago. No.
It's a no. My lord, kindly seize the order dated 21st September
Sir,
2024.
please give us a copy of that miscase, of that application. What application was filed? We have to know that also. Under which provision? We'll ascertain the level of wrong advice from that. Whether it was actually erroneous advice or it was your machination.
Not next.
Acha,
Lord,
there
I
are
only have the order, my lord.
No, we require a copy of the application. Acha, there are certain defects also. Date of judgment. Please go through the defects and carry out the rectifications in the memorandum of appeal. Acha, one other thing. There is an office report that this is not maintainable before this court. The valuation is 1895 rupees.
Valuation.
You valued the appeal as 1895 is not maintainable before this court.
Wrongly reading.
You have evaluated the appeal memorandum as 1895.
Lord, perhaps, my lord, by mistake, my lord.
What should be the real valuation then?
Wrongly reading.
It is typographical, my lord.
Typography means what is the actual valuation then? Where is the plaint? Come prepared with a copy of the plaint, Mr. Nandi.
My lord, my lord.
At the time of hearing, it transpires that there is an office report which indicates that the valuation of the appeal is rupees 1895, and as such, the appeal is not maintainable before this court. Apart from that, full stop there. Apart from that, there are other defects also. Full stop, the learned advocate on record for the appellant is directed to carry out the necessary rectifications in the. আচ্ছা না এটা ছেড়ে দাও learned advocate টা হবে না the other defect has to be cured by sending the matter down that will do later next para learned counsel for the appellant submits that the valuation of the memorandum is a typographical error full stop however we do not learned counsel for the appellant is not equipped with a copy of the plaint of the suit for us to ascertain the actual valuation of the suit nor is any copy of the miscellaneous case, which was allegedly filed by the appellant in the meantime and is the ground of condonation of delay, available with the learned advocate for the appellant. First up, accordingly, the learned advocate for the appellant is requested to bring sufficient copies of the plaint of the suit as well as the miscellaneous case allegedly filed in the interregnum by the appellant against the impugned order on the next date to enable the court to pass an appropriate order. First up, next para. The matter shall next be listed on how soon can you bring that copy of the plaint and the other?
4 weeks.
My lord, within 4 weeks.
4 weeks?
Yes, ma'am.
Which district? South 24 Alipur. Why 4 weeks?
Alipur.
Alipur. Anyway.
The last page of the decree reflects 1895 last page of the
even
decree.
then we want to see look at the plaint to be sure
Very
and they are not enjoying an interim order so they are asking for 4
Yes,
weeks.
millet. But this one they have not paid millet only.
My lord, I have paid.
This month have you paid?
Let the matter be listed next on November 17, 2025. Come back on 17th November.
I'm grateful.
If they don't pay, you execute.
My lord, I have paid this month also.
Next.
Grateful.
Item number 14.
Yes. None appears for the parties. Adjourn for the day. Acha, none action. We find from the order dated October 28, 2025 that none had appeared for the petitioners at the time of call, and we had made clear that in the event the petitioners do not move the matter On the next occasion, the matter would be taken up for hearing ex parte. Full stop. Accordingly, the matter is taken up ex parte. Full stop. However, comma, since the respondents are also not represented, comma, we grant a further chance to the petitioner to move the matter. Full stop. Accordingly, let the matter stand adjourned for the day, with a reiteration that the matter shall be disposed of ex parte on the next occasion if none of the parties appears.
Item number 15.
I'm appearing for the
Yes, Mr.
appellant petitioner. No, my lord.
No caveat?
My lord, this is first time appearing. First appearing, my lord, my application is for injunction, my lord.
No caveat is there, obviously.
No.
What is the matter about?
I tell your lordship, my lord. What happened, my lord, in this, my lord, my suit for specific performance, my lord, has been, my lord, dismissed.
Oh, this you started this matter, yes?
System. Now, my lord, the ground of dismissal is, my lord, I could not prove the title of the vendor. Now, my lord, first, foremost, my lord, bit of fact is required because, my lord, the property undoubtedly, my lord, we have produced the registered deed of sale, belongs to Pushpa Rani Pal. Now, my lord, Pushpa Rani Pal purchased the property in the year 1965. My lord, she had one minor daughter, namely Lakshmi Rani Pal. Now, my lord, Pushpa Rani Pal died. My lord, after her death, there being no legal heir, the maternal uncle of Lakshmi Rani Pal, my lord, obtained a order from the civil court as appointed as a guardian of the minor body and the property both. Now, my lord, in the year 1975, my lord, we came to know the minor went missing. Now, my lord, we contractor entered into this agreement for sale with the heirs of the maternal uncle, my lord, in the year, my lord, 2000.
Maternal uncle was, he also died in the meantime.
Yes, maternal uncle died, the heirs inherited the property.
Under normal line of succession, they would have inherited.
No, my lord, under Hindu Succession Act, as my lord, Pushpa Rani Pal had the husband predeceased the wife, and my lord, the daughter, there was no heir. So, my lord, the father's heir was also not, so it revert back to the mother's line.
Then to you.
That to my vendors.
No, not to you, your vendor.
My vendors, my lord, defendants line. So, my lord, by virtue of that, the heirs of the, my lord, defendants
Daughter
line.
was missing for more than 7 years.
My lord, 1975.
Poor daughter. Yes. So now you enter into a contract with the heirs.
Yes.
That is the specific of one suit. They are not selling.
They are not selling. They do not enter appearance suit, my lord. They do not contest.
So what sort of title deed should you have produced according to the
Yes,
trial?
exactly, my lord. My lord, the court says the daughter is the property of the
Pushpa's purchase deed you have produced.
Yes, that we have exhibited.
Regarding heirship or anything else you have not produced.
Sir, I cannot produce the heirship.
And there are your adversaries now.
There is no
Special
adversaries.
knowledge.
Yes.
This is injunction application.
This is my injunction application.
The present appeal has been preferred against against a judgment and decree whereby the suit for specific performance of a contract for sale instituted by the plaintiff's appellants was dismissed. Full stop. The primary ground of dismissal was that the title of the vendor could not be established by the appellants. Full stop. The case of the appellants is that one Pushpa was the original owner of the Pushpa Rani Pal was the original owner of the suit property. Full stop. After Pushpa Rani Pal passed away in the year 1966, comma, her minor daughter, one Lakshmi Rani Pal, who was aged about 6 years, inherited the property from Pushpa. Full stop. However, comma, the minor girl went missing in the year 1975 and was never traced thereafter. Full stop. Thereafter, the maternal uncle of Lakshmi Rani.
Maternal uncle of Lakshmi Rani Pal.
The child. Maternal uncle of Lakshmi Rani Pal, comma, after obtaining appropriate permission from the court, comma, entered into. What did he do after?
Milord, in the year 1966, when Pushpa died, maternal uncle obtained, Milord, as a became the guardian by virtue of a court order.
যেটা বললাম সেখানে comma became the guardian, the legal guardian of Lakshmi Rani Pal. Push up. Since Lakshmi Rani Pal went missing for more than 7 years, comma, the maternal uncle became the owner of the property, and after him, his heirs and legal representatives. Full stop. Next para. The present plaintiff stroke appellants purchased the entered into the agreement for sale with such legal heirs and successors of the maternal uncle. Full stop. Next para. As such, comma, a relevant question has been raised as to what other documents could have been produced by the appellants apart from the purchase deed of Pushparani and comma by oral evidence comma establishing the heirship of the proposed vendors of the appellants. Full stop. Next para. Since the above question and other questions of fact and law are involved in the appeal, comma, we find that a strong prima facie case has been made out for hearing of the appeal on merits. Full stop. In view of the averments made in the injunction application, comma, we are of the further opinion that unless an injunction as prayed for is granted, comma, the appeal might be rendered infructuous. Full stop. Accordingly, the respondents are restrained by an order of injunction from the respondents and their men and agents are restrained by an order of injunction from changing the nature and character of the suit property and or creating any third party interest in the said property during pendency of the application. Full stop. The petitioner shall serve copies of the application bearing can 1 of 2025 on the respondents, indicating that the application shall be listed next on November 24, 2025, when an affidavit of service shall be filed by the appellants.
Item number 16.
But I appear for the appellant.
Claim for the plaintiff.
Now, there was a direction, my lord, passed by your lordships, my lord, to serve, my lord. We have served my learned friend is appearing. Now, my lord, one Gopal Chandra Ghosh, he was the defendant, my lord, in a suit for specific performance of contract. Now, my lord, this suit was filed on, my lord, 1st of December 2020. Now, my lord, Gopal Chandra Ghosh, my lord,
you are the defendants.
My lord, I am the sole defendant in that suit. Now, my lord, Gopal Chandra Ghosh, I have annexed medical documents to show, my lord, he was a septuagenarian. My lord, he faced an accident. My lord, he broke his ribs, my lord, his femur bone, and was completely, my lord, bedridden. Now, my lord, he appeared in this suit on one day, filed his vokalatnama, my lord, and prayed for time to file written statement. Thereafter, his condition completely deteriorated. He was in bedridden, my lord.
Who had filed the suit?
My lord, the suit was filed by one Lilu Ghosh. My lord,
my client.
My lord, friend's client.
That is what we are.
Now, my lord, he was completely bedridden for 4 years. After that, my lord, he died. My lord, we are the legal heirs, my lord, of my lord, of Gopal. My lord, we came to know about the suit after the judgment and decree was passed. When the execution proceedings started, we were sent a copy of the draft deed. Now, my lord, thereafter, my lord, we have come up in appeal. Now, my lord,
Section 5 is there.
Section 5 is there. There is a delay of 813 days. Now, my lord, kindly sees, my lord, the medical documents.
So you have sought made an application for leave to prefer the appeal also because you are not parties in the trial court.
No, my lord, here, my lord, we have not filed an application for leave to prefer an appeal. If your lordship says, my lord, we can file.
Because otherwise, you are not parties there.
Yes.
Formal application has to be filed. One-page application.
I'll file it. I'll file it.
And what about the circle rate of the plot in question?
The circle rate, my lord, we could not obtain. We have obtained the market value of the property in question.
Justice Shane's bench was of the impression that
yes,
you have to deposit the money.
That was the COVID time, my lord. They do not have the records, I am told. That, my lord.
This is for what? It was their suit. Their suit for specific.
Their suit for specific performance of contract.
So why was the circle rate asked for?
Because, my lord, lordship was of the view that if it could be settled, lordship seeing the market value of the property.
Actual market value at the relevant point.
But this is, my lord, we have
possible to settle, then settle. No difficulty. Will grant to leave to file the leave application in the
lordship. But we have obtained it. Presently, it is valued at 15 lakhs.
Present valuation will not do, man. At the valuation at the relevant point of.
Their case is that 3.50 lakhs was the total agreed amount, out of which he paid 1 lakh, 2.50 lakhs at the time of. But we have a specific case, the agreement for sale, but was dated 1st of January 2020. Lordship would see the stamp paper. It was purchased on 3rd of January 2020. Now, that was produced by him as an exhibit before the learned trial court, but we could not my lord, we did not know about this suit, my lord, we could not raise this contention. there.
Pursuant to the previous direction of a coordinate bench, comma, an e-assessment slip is filed by learned counsel for the appellant, indicating that the market value of the property in question is about rupees 15,35, 438 oblique dash. For sub next para, the matter arises out of a suit for specific performance which was decreed in favor of the respondent. For sub next para, the appellants claim to be the heirs of Gopal Ghosh, comma, the defendant in the said suit who met his demise in the meantime. For sub next para, it is the case of the appellants that the appellants learnt about the decree much thereafter at the execution stage and have preferred this appeal. Consequentially, there has been a delay in preferring the appeal. Next para. However, comma, we find that there is no application on record by the appellants seeking leave to prefer the appeal, which is mandatory in view of the appellants having not been parties in the trial court. On the prayer of the learned advocate for the appellants, comma, leave is granted to the appellants to file an application for leave to prefer, file a formal application for leave to prefer the appeal. A copy of all the applications, comma, if not already served, comma, shall be served on the learned advocate for the respondent in the meantime. Let the matter be listed next on November 10, 2025. The learned advocate for the appellants is granted liberty to mention for inclusion in the list along with the present applications, the proposed application for leave to prefer appeal as and when filed. It will appear on 10th of November. Immediately file that leave application and mention it for us next week. Give a copy to him. So
Before
that
the Honorable Justice Sen, my lord, I wanted to file one appeal in opposition to the Section 5 application. Since my lords were of the opinion that you try to settle the matter, that is why my lord, liberty was granted to me.
Well,
to file the
affidavits in connection with the application for condonation of delay, comma, if any, shall be exchanged in the meantime. Do that as fast as possible so that he can come prepared with the report.
But only one thing, my lord, before the executing court, my lord, the date is on 1st of December. So, my lord,
we are taking up on 10th November.
10th November.
10th November.
Item number 17.
Yes, Mr. Otachari.
Pursuant to your lordship's last direction, my lord, copies have been served.
Lord, I am for the defendant.
Oh, you are appearing. You are appearing for all the respondents?
Yes. No, respondent number 1. Plaintiff in the suit, man.
Plaintiff. Respondent number 2, my lord.
Even in one cell with you in the.
Yes.
So we can dispense with service of on respondent number 2. Yes, there is a section 5 application.
Section 5 is can 2, my lord, 131 days delay. My lord,
what is the reason for the delay?
Reason, my lord, the certified copy and other pleadings were obtained, but the clerk, my lord, of the learned advocate in the trial court, he misplaced it, and a new set of, my lord, documents, my lord, have also annexed the new set of documents, certified copies of the pleadings, and now, my lord, appeal has been filed. If your lordship would kind enough to consider, my lord, the can 1.
Yeah, and the pleadings here have annexed as certified copies.
Yes. Lord,
nobody would go to that extent to tell a lie to the court. Any certified copies is more costly than preferring.
Kindly see page 8 of can.
We believe them. We are allowing. We are recording that you are objecting, but we are allowing this section.
Then we'll take up this. I will only state before your lordship kindly peruses 11 and 12. Otherwise, I am not.
11 and 12. Paragraphs 11 and 12.
Yes, my lord. They are
can 1 or 2.
Two.
Otherwise, I am not on
renovation work and all.
Yes, that's why, Milord, due to renovation, there was a shifting, and Milord, the brief got misplaced.
Good storytelling gets its prizes. It has to be credible.
And my lord, the cost item. Both are appellant. Appellant versus appellant.
Your learned friend is absolutely right. And he's a regular in the civil court, it's very evident.
Yes.
Leave is on the pair of learned counsel for the appellant. Leave is granted to the learned advocate on record for the appellant to carry out the necessary correction in the cause title of the applications and the memorandum of appeal insofar as the nomenclature of the plaintiff stroke respondent number 1 is concerned. Next para, nomenclature, classification of the plaintiff stroke respondent number 1 is concerned. Next para, upon hearing learned counsel for the parties, comma, we find that sufficient explanation for the delay in preferring the appeal has been made out. Full stop. Accordingly, can 2 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 373 of 2025. Full stop. This is against what judgment?
Milord, against Milord, the judgment passed in a suit for specific performance of contract.
Decreed?
Yes, decreed against my client.
What is the, you are asking for stay?
Stay.
Yes, what do you say to this?
My lord, I vehemently oppose against the stay. My lord, kindly visualize this. I have paid the entire consideration amount. Now, only a fraction of the amount is left. Otherwise, I have paid almost the maximum amount I have paid. There
that
is
paid pursuant to direction of court or previously?
previously, and there has been an agreement. Yes, their contention is that agreement is not registered. Be that as it may, but there is an agreement, written agreement, and all the transactions are made through cash as well as online check. So there is everything to substantiate, and everything are on exhibit.
What is the amount you have paid?
8 something
lakh.
Yes, my lord. Now, after the decree and after decree drawn up, and that too after some 131 days, they are coming and asking for stay, my lord. I am not on the way. Kindly decides on merits, my lord.
Kindly, Milord, hears out the Milord appeal today itself. Milord, first of all, Milord, they have claimed Milord part performance on the basis of an unstamped and unregistered
The
document.
documents, all relevant documents have been annexed. Evidence. Then how can we hear
No,
the
that is I'm placing.
prepare informal paper books?
But kindly grant stay, Milord, execution.
Yes, we'll grant a limited stay. We'll grant a limited stay.
Because on the face of it, the suit should go in view of section 53A. They have claimed part performance on the basis of Milord and
We
unregistered.
take up the stay application for hearing. Full stop. Next para, learned counsel for the respondent submits that learned counsel for the plaintiff stroke respondent number 1 submits that the plaintiff has expended substantial amounts of money to the tune of more than rupees 8 lakh by way of part of the consideration for the agreement in question. Full stop. Next para, it is submitted that there is no merit of the appeal and as such no stay ought to be granted. So learned counsel for the appellant contends that the agreement in question was unregistered and
unstamped also,
and as well as unstamped. Full stop. Next para, at this juncture, learned counsel for both the parties submit that they are otherwise agreed to argue on the main appeal itself. So, however, we find from the records that copies of the entire evidence are not there on record. Full stop. Next para. In view of the urgency involved on the part of both sides, we direct the appellant to prepare and file the requisite number of informal paper books without comparing with the records, annexing all relevant documents, incorporating all relevant documents, and serve a copy thereof on the learned advocate for the plaintiff stroke respondent number 1 within 3 weeks.
Milord, this will be a problem because I have to, Milord,
do you have copies of
certified copies of the plain and written statement? Milord, entire brief is lost. Milord, I do not have.
No, that you have. Certified copy of
only the plain and written statement. Milord, evidence, documents, Milord, exhibited.
Whatever copies you have
will be necessary.
We'll give you 4 weeks time then.
Then comparison and LCR 4 weeks from the date of arrival of service of notice of appeal of the court records, because I do not have anything, Milord. I have obtained, Milord, somehow the plain and written statement.
We were thinking about dispensing with the records if you have the copies. Do you have the copies of all the evidence? Then we have to grant.
Milord, for the
We
purpose
have
of
the copies
drafting,
most of, but then again we cannot assure.
For the purpose of drafting, Milord, my client obtained these.
Within
Milord.
4 weeks from the date of service of notice of arrival of the trial court records on the learned counsel for the appellant. Full stop. Next para, service of notice of the appeal on the respondent number 1 is dispensed with in view of appearance through counsel. Full stop. Service of notice on the defendant number 1 stroke pro forma respondent number 2, who was sailing in the same boat as the appellant in the trial court is also dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The there shall be stay of operation of the impugned judgment and decree till January 31, 2025 or until further order, whichever is earlier. Full stop. Liberty to the parties to mention the appeal for hearing along with the application for stay as and when the appeal is ready for hearing. We are keeping the stay application pending so that he'll have a handle to mentioned and making the order limited.
My lord, only one innocuous
And
prayer.
affidavit of service filed to the kept.
Yes, my lord, only one innocuous prayer. If your lordship kindly peruses this order, out of 10 lakhs, 8,70,000 has been paid. So, my lord,
1,30,000 remaining.
yes, only that amount is remaining. So, if a date may be fixed, my lord, otherwise, if it will not come, my client will be prejudiced.
Date for what?
For hearing of the.
No, we are making an exception by granting stay for a limited period. Otherwise, you grant stay till disposal of the appeal. We are making it till 31st of January because we have to give a reasonable time.
Very well, my lord.
Whatever.
I'm grateful.
Grateful.
Item number 18.
This is my immediate service in terms of the direction of the Honorable Court, my lord. We serve, my lord.
Service has been affected, Mr. Datta?
Service affected, my lord.
Right. What is the matter about?
This is my lord, land acquisition matter, my lord, relating to my lord, section 18. Other side is not here today. Only, my lord, from my brief, my lord, I find that there are 30 days delay, and I have not checked up, my lord, the office report.
Thank you.
And in this matter, in connection with this self-acquisition, your lordship will earlier
25 days
25.
delay, it says.
I have
You have filed a section 5?
section 5 application.
You have filed it?
I have filed it. I have served also, my lord.
No, you have not. Name of respondents 3, 4 and 5 are not there in the impugned judgment.
That's why, my lord, on the...
You have to make an application for leave.
My lord, only, my lord, on 17th September 2025, there was an order. That office report was wrong.
Oh, acha. No, but nothing is...
On 17th of September 2025.
Impugned degree is bereft of the name of the parties. Not your fault. Trial court's decree does not contain the names of the parties.
No, my lord.
No, report is wrong. Decree name is there.
Name is there.
All the names.
That's why, my lord, earlier order passed by this honorable court, my lord, there was a direction upon the office, my lord, to submit a report.
Acha, let us see that.
And on 17th of September 2025, you lordship kindly it is the, my lord, order, solemn order of this honorable court, my lord. Department shall file a revised report after verifying the original record, as it appears that there are some obvious mistakes in the endorsement made by the department.
Yes, but the report is also peculiar. That name of respondents opposite parties in the instant appeal has been inadvertently written in the first sheet as Nasiruddin and whatever. That is regarding the names not being there in the decree. But
Yes.
is it a fact that you were not parties in the appeal? Some of the respondents were not parties in the
No,
appeal?
my lord, everyone, my lord, you lordship find it from the record.
Let
my
us
lord.
check up. Let us check up. The office report says that
My lord, my lord, the decree, my lord, must be sent to the department, my lord, my court below, my lord. But you also find from the decree
2AC
SP, my lord, Sheikh Nasiruddin and others. But all details has to be, my lord, incorporated in the decree.
3, 4, 5. Oh, acha, and 4 others may include them. First, the decree has to be sent down. Then now we
Yes,
cannot
yes.
do anything.
That's it. That is the defect, my
We
lord.
find from the decree, certified copy of the decree of the trial court, that the name of the plaintiffs have merely been mentioned as within double inverted Sheikh, SK Sheikh, full stop, Nizamuddin, and 4, numerical 4. 4 others.
4 others.
Comma, instead of
Details, my lord.
mentioning the particulars of each of the plaintiffs. For the next para, unless the decree is rectified, comma, no order can be passed in the matter, comma, as it cannot be ascertained as to whether the parties in the appeal tally with those in the court below. Full stop. Accordingly, the trial court's decree be sent down immediately for necessary corrections by incorporating the full particulars of all the parties to the proceeding. Full stop. Next para. The department shall take steps for communication of this order to the trial court, as well as for sending down the certified copy of the decree for such correction at the earliest. Full stop. Upon the decree being rectified and sent back to this court, comma, the office shall furnish a revised report, so liberty to the parties to mention the matter after such correction is effected.
On affidavit service may be kept on record.
Affidavit of service filed today be kept on record. Thank you, sir.
Deeply obliged.
Item number 19.
May I please, Your Lordship, I am
Here for the
responding
appellant.
by my husband, my lord.
Appellant, why you are for the Ms. Basutakur, you are for the appellant wife.
Yes, my lord.
So this is against divorce decree.
Yes, my lord.
Divorce is granted.
Yes, my lord.
You have remarried.
No, my lord.
Then don't will grant stay. The other must be for alimony, yes, sir.
No, the
Thank God.
No.
was for my lord. In the
She is
meantime,
school teacher, my lord, and she is earning, my lord, 68,000 per month.
You have applied for alimony. Then you apply for alimony. Hindu marriage.
Hindu marriage.
You are also entitled.
Well, I am also, my lord.
You are also a school teacher.
My lord, I am a clerk, my lord.
Anyway, an application for expunge means what
My
sort
lord,
of an application is this?
My lord,
My lord, OP number 2, my lord. Respondent number 2, my lord.
lady was involved with OP number 2, my lord.
Decree was passed for
Adultery was there.
Let her finish. Yes.
decree was passed for cruelty, living adulterous life, and
He was also passed on the ground of adultery.
adultery, cruelty, and desertion, my lord.
Then
And
two is
in
a
the
necessary party, adulterer, alleged adulterer.
Yes, my lord. But in the
Who have
meantime,
sought for
no,
expansion.
my lord, in the meantime, the respondent
died,
was
my lord.
died, my lord. During pendency of the suit, the respondent number 2 was died.
Then we are expunging his name. We are allowing this application and granting stay also. You will prepare the paper books and all. We are passing the usual direction regarding paper book and trial court record. Can 2 of 2025?
My lord, one humble prayer, my lord.
Yes.
The stay should be some limited period. Otherwise,
Limited. What is the meaning of that? You now know of the appeal. You cannot remarry in any law. You can. So we'll direct expeditious. If you want, we can direct you to prepare the paper. So would you like to take
no,
the life?
no, my lord. It is their duty.
Can 2 of 2025 is an application for expunging the name of respondent number 2. Full stop. It is submitted by learned counsel for the appellant that the respondent number 2 has met his demise in the meantime. Full stop. It transpires from the frame of the suit that the same was for divorce internally on the ground of adultery. Full stop. Next para. Since on the demise of the respondent number 2, comma, the cause of action and or right to sue with regard to him does not survive on his heirs, comma, can 2 of 2025 is allowed, comma, thereby directing the name of the respondent number 2 to be expunged from the appeal. Full stop. Necessary consequential corrections to the memorandum of appeal shall be carried out by the learned advocate in record for the appellant during the course of the day. Full stop. Next para. Since the appeal arises out of a decree for divorce and questions of both fact and law are involved, comma, unless the respondent is restrained by an order of injunction from remarrying, comma, the appeal will be rendered infructuous. Full stop. However, comma, we are not inclined to grant blanket stay of the impugned judgment and decree since the same is in the nature of a judgment in rem. Full stop. Accordingly, we choose to mold the relief prayed in Can 1 of 2025. Full stop. Can 1 of 2025 is allowed on contest, thereby restraining the respondent number 1 by an order of injunction from contracting any remarriage during pendency of the appeal. Full stop. Next para, there will be no orders to cost. The trial court record shall be brought by special messenger as at the cost of the appellant to be deposited within a week from date. Full stop. Next para, in view of appearance of the sole respondent number 1 through his learned advocate, comma, service of notice of appeal on the respondents is dispensed with. Full stop. Next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My lord, affidavit of service.
Affidavit of size filed to be kept on. Please give your name also for the records. Yes.
Item number 20.
20, I appear for the appellant.
Yes, Mr. De.
Yes,
What is
my
that?
lord, the appeal arises out of a probate proceedings.
Probate
My
proceeding.
probate application has been dismissed by the learned trial judge.
By dismissed?
Dismissed because
Yes.
it was heard previously by Justice Sen's division bench. There is an order also to that effect. But dismissed to that effect, my lord, one non-exhibited document, that is the report of the handwriting expert, the learned trial judge has taken into consideration. But that handwriting expert's report has not been exhibited.
Not exhibited?
Not exhibited. Very surprising thing, my lord. Not exhibited, and the court has relied upon it solely. It is the settled law, my lord, the handwriting expert, he has to come to the box, he has to face the cross-examination. Nothing has been done.
You are asking for injunction?
No, there is no mistake. No, there is already an order of the Justice Sen's division bench. My lord. Kindly look at it.
Stay, what is the meaning of stay, Mr. De? Probate has been dismissed.
Dismissed.
Stay, what does stay mean?
My lord.
Justice Sen also granted stay.
But injunction, I need injunction with this. Or you can mold the deal.
Injunction, stay means the suit will be revived.
Yes, that's.
You ask for stay. You asked actually for the judgment to be set aside.
Yeah, actually, that is my main prayer.
But can that be granted in the stay application? No, but have you? There is no averment regarding.
But there is an averment that
they're trying to. Where is that?
Dispose the.
Show us that averment that will mold the relief then.
Yes, sir.
Show us that averment.
Yes, yes. Not page 10, paragraph 24.
Yes, this is sufficient. Although an ad interim order of stay was granted, comma, we are of the opinion that stay would not serve any practical purpose, comma, since the appeal has been preferred against the dismissal of a probate suit, and grant of stay would merely revive the appeal temporarily, revive the suit temporarily, which would not inure to either party's benefit. For the next para, however, comma, we find from the averments made in the application that a sufficiently strong prima facie case for injunction has been made out, inasmuch as the respondents are trying to dispossess the appellant from the suit property. Moreover, comma, keeping in view the fact that several arguable questions of law and fact are involved in the appeal, comma, we find that a sufficient prima facie case for grant of injunction has been made out. Moreover, comma, the balance of convenience and inconvenience, as well as the irreparable injury factor, operates in favor of grant of injunction. Next para, as such, comma, we choose to mold the relief sought in Can 1 of 2025. Can 1 of 2025 is accordingly allowed, comma, thereby restraining the respondents and or their main and agents from selling, transferring, alienating, or encumbering the suit property in any manner, comma, from changing the nature and character of the suit property, and or from changing the status quo with regard to possession in respect of the subject property of the will till disposal of the appeal. Next para, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall deposit postal costs and other requisites also within a week from date, comma, for service of notice of the appeal on the respondents. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. আচ্ছা, একদম প্রথমে চলে যাও, একদম যা হলো একদম প্রথমে affidavit of service filed to be kept on record. None appears for the respondents despite you have checked up good services.
Only one has not received out of 6, my lord.
Despite substantial service having been effected on the respondents. Accordingly, Can 1 of 2025 is taken up for hearing expert. That one person contested with the others in the court below?
Yes.
Together? That is substantial.
Yes, all 5 have been served, my lord.
No, 5 have been served, but 6.
So one contested, only one, the nephew. The testator was the.
He has been served.
Yeah, yes, he has been served. He has been served.
That is sufficient.
But so interim order will continue till the disposal of the appeal.
Injunction বললাম till কততে বলিনি না? During pendency of the appeal বললাম.
Disposal of the appeal.
Till disposal.
Grateful.
Yes.
Grateful. Much.
Oh, I have another bench actually. Sorry. Yes. Sorry, Mr. Chandra.
Grateful to your lordship.
Another bench.
Much of best.